Good morning, folks. This is the Colorado Oil and Gas Conservation Commission. We are in hearing this morning. It is April 14th and it is 9 a.m. and we will start our meeting with a roll call.
Thank you, Mr. Chair. One moment, I need to.
Welcome back, Hearings Manager Larson. It's great to see you.
Thank you very much, Mr. Chair. And we will get started with a roll call. One moment while I get that populated. Commissioner Bogue.
Here.
Commissioner Gonzalez.
Here.
Commissioner Hackett.
Here.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Nanjapa.
Here without some video capabilities.
Commissioner Robbins.
Here.
Thank you, Mr. Chair. We have 9 out of 9 commissioners present.
Or 7 out of 7, but.
Thank you. Forgive me. I would like to say it's a Monday morning, but it's Wednesday, so I can't blame it on being Monday morning.
It's just great to have you back. Hearings Manager Amaro and Hearings Manager Thomas did a great job in your absence, but it's good to see you back with us and welcome back.
Thank you.
So first order of business is just to mention to our listeners and to the commissioners that we did alter the agenda yesterday ever so slightly. Everything that was previously on the agenda remains on the agenda. We just altered the timing of some of the presentations to accommodate some of the presenters with regard to calendars. That altered agenda is on our website, so encourage folks to go ahead and take a look at that. I'm going to roll through it just real quick, and I think we also have a alteration to the consent agenda. We'll start with public comment. We have one public commenter this morning. We have reports from the Executive Director's Office and from the Director. We have a staff informational presentation on interaction of surface rights and mineral development, followed by 2 industry panels on the interaction of surface rights and mineral development. We then have a scheduled lunch break with a staff follow-up to the industry panel, followed by a presentation from CDPHE about supplemental environmental projects. We then have a consent agenda, and then we end with commissioner comments. So I don't normally rattle that off, but that is a revision to the published agenda from last week. It is all proper and appropriate, and so that's how we will go about our business this morning. Hearings Manager Larson, we had 3 items on our consent agenda. I understand that perhaps one item is going to be pulled. Would you like to speak to that?
Yes, thank you, Mr. Chair. Item number or docket number 2007-00176, Bonin and Yuma. That matter we are pulling from the consent agenda. A question has come up with respect to the calculation of one of the figures that is set forth in the proposed order. So we're going to pull that, take a review of that, and then we'll bring that back to you for consideration at a later date.
Okay, so that item is no longer on the consent agenda. So when we get to that, we'll need to make sure that we note that that was pulled. At this time, we would move to public comment. We allow for public comment at each of our weekly meetings. This week, we only had one person sign up for public comment, and that is Christy Nyholm. And I'm looking to see if we have her with us at this point in time. Hearings Manager Larson or Mr. Thomas, do we see Ms. Nyholm?
We have not yet found Ms. Nyholm in our list. We'll continue to look. It is 9:05. She's not yet entered the meeting, but
Okay.
as soon as she does, we will alert you.
Yeah, why don't we just hold on that public comment? Since there's only one public commenter, we can roll back to that, and we'll just continue down our agenda. Next, we would have a short report from the Executive Director's Office, Commissioner Bogue.
Thank you, Chair. So just a quick update from me on behalf of Executive Director Dane Gibbs. On the budget front, the long bill, the state budget has passed through the House, or sorry, passed through the Senate and is on its way to the House, where there are several amendments that are proposed. And so we will be navigating through that. But it's exciting, you know, there's a lot of investment for important issues like wildfire risk mitigation. So that's rolling along in addition to some of the investments that are being made through the Colorado recovery plan, which the public may have heard is a $700 million state stimulus package to help the state build back stronger following the pandemic in the current fiscal year. And that plan also includes some funding for wildfire risk mitigation projects, watershed restoration projects, and projects that support the Colorado Water Plan. And so DNR is continuing to work with the governor's office and the legislature on determining exactly how those investments will be rolled out. Another really important topic DNR has been focusing on is around Proposition 114 to bring wolves back to Colorado. And so right now we're finalizing the stakeholder engagement process. So shortly we'll be opening up that conversation to the public in a public engagement process. And we're really looking forward to working with the public on that very, very big and very challenging issue. So those are really the main points that I wanted to highlight today. Yeah, I'm open to any other updates that commissioners or members of the public would like.
Thank you very much, Commissioner Bogue. Do any of my fellow commissioners have questions? Great, seeing none, we will continue forward. I see that Deputy Director Scott Cuthbertson showed up and now he's disappeared again. Now he showed up again, now he disappeared.
I'm not sure what's going on with my camera. It does not want to stay connected.
We can hear you okay, Director Cuthbertson.
So Scott Cuthbertson, Deputy Director for COGCC. I'm here today for Director Murphy, who's taking a few well-deserved days off. So I will be your contact the rest of this week if there's anything you know that needs a quick interaction with our staff. Be happy to be able to answer any questions that might come up. Just a few brief comments. We are still actively engaged in the implementation of the mission change rules that were effective January 15th. I am planning an update presentation from our technical services manager, Jane Stanzik, in the very near future to sort of line out maybe the next couple of 3 months vision of where we are with that and the next steps. We have a really important technical transition to make. Our Silverlight-based e-forms is no longer supported and has not been for about a year, right? And so we have a project that we have in place to change over to a different technology, and I want to just lay that out for the commission. So we'll be doing that presentation in the coming week or so. We have been continuing to meet with stakeholders on mission change implementation, including what are now bi-weekly operator trainings. We did weekly operator trainings for the better part of 2 months, a little over 2 months. And those were, I think, very successful in helping promote conversation with the administrated entities in the Oil and Gas Conservation Commission. And our next operator training is Tuesday, April 20th. Those are open trainings. It's not limited. You know, it's an open session. So I encourage commission or listeners to listen in and be able to gain insight from that. We have continued to work on addressing some of the commission's questions regarding financial assurance. And we expect to have a good update next week. Right now, we're just assimilating the responses to the number of questions that we captured in the informational docket sessions, and so that's proceeding as at a good pace. we really don't have any updates in regard to any kind of local government activity. We do have a staff update. I'm pleased to announce that we have been able to replace retired GIS analyst Dennis Allstrand with a new hire, David Gates. Comes to us from a very well-known and reputable consulting firm here in the Denver area that I will not name because I don't want to rub it in that I've taken one of their good assets, which is probably the second or third time I've done this in 20 years. But David's got a lot of great experience, was their principal GIS asset, like I said, a major consulting firm here in the Denver area. And so he comes in hitting the ground running. I couldn't be more excited to be able to have a great replacement for a great asset in Dennis Allstrand. I also appreciate Dennis came back to work out of retirement temporarily to help us facilitate mission change implementation. As you know, there was a significant amount of mapping information and data that was associated with our mission change rules. And so Dennis did come back out of retirement and helped us temporarily. His last week will be either this week or next. And then David will be completely up to speed, I think, and able to carry on. So that's all the report I have. Commissioners, I'm happy to respond to any questions if you have any.
Thank you, Director Cuthbertson. Appreciate those updates. I'm thrilled to hear about your new hire. It obviously is an exciting time and applicable time to get a good OIT person on board to help us with GIS, et cetera. So great job there. And thank you for the report. Do commissioners have any questions? Okay, seeing none. I'm still not seeing our public commenter in the public comment portal. Hearings Manager Larson, just keep track of that. And if we do find Ms. Nyholm, we will circle back and give her a chance to speak.
We certainly will.
With that, I think we're moving toward a staff informational presentation on interaction of surface rights and mineral development. And I believe that we've got Environmental Manager Greg Durunlo to present. Good to see you there, Greg. Look forward to hearing from you.
Hello there, and thanks, Chairman Robbins. Before I get started, I want to make sure you can hear me. I'm not using a secondary microphone. Great.
We can hear you fine.
Then the next technical issue to cover is sharing my screen, so I'll give that a try. And I'm hoping you can all see my screen.
You're batting 1,000, Mr. Durunlo.
All right, well, now let me just see if I can move some things around on mine so I can see my notes. And now my batting average is going down. All right, well, good morning, Commissioners and Chairman Robbins. Thank you for the opportunity to speak to you today. Commissioner Gonzalez has put together an important informational docket in which you will hear from a number of industry panelists, and I will be providing the staff perspective. We will be covering many facets of surface rights, surface development, and planning for oil and gas operations on the surface of the land. I am Greg Durunlo. I'm the Environmental Manager here at COGCC, and the Oil and Gas Location Assessment Team within my work unit is primarily responsible for reviewing the surface development permit applications, including the Oil and Gas Development Plan, or OGDP, the Oil and Gas Location Assessment, or Form 2A, and the Cumulative Impacts Data Evaluation, or Form 2B, as well as any comprehensive area plan applications in order for the director to make her recommendation to approve or deny any permit application. So today I will focus on the aspects of planning that interface directly with the oil and gas development plan application process. I believe the industry panelists will provide more specifics on their implementation of the planning process, but I'll start with a high-level overview and then dive deeper on the topics of the right to construct and surface constraints. All of this feeds into the alternative location analysis and planning process from which the COGCC applications can be built. So by way of introduction, we're going to begin with the end in mind. For the operator applicant, their end goal is an approved permit to develop the mineral estate from a given surface location. For the state, our end goal is a protective permit that minimizes adverse impacts. These two goals are not incompatible. In fact, we've never been in a better position to ensure the successful synthesis of these goals, and we have a tool now in our toolbox that provides for the denial of a surface development plan if it's not deemed protective. With that in mind, let's take a look at the surface selection process from COGCC's staff's perspective. You'll hear from operators in a few minutes, but for staff, it looks like this. First, operators will consider their subsurface mineral position. Second, they will reflect that up to the surface and start looking for available land. Given the constraints at the surface, they will select the best location from which to develop. And at this stage, it is our strong hope that the COGCC alternative location analysis process is forefront in their planning processes. The operator will engage landowners. The operator will evaluate local government considerations and local permit processes. They will conduct pre-application notifications and consultation. And finally, they will file a permit applications with the state, followed by additional notifications, consultations, and of course, public comment and the COGCC technical review. Commissioners, the rules you are all familiar with after last year will drive much of the surface selection. Numerous rules, including those listed here, will all factor into the decisions an operator makes when siting a location. A really important concept to discuss when considering the use of the surface for oil and gas development is right to construct. Much of the discussion around right to construct is grounded in statute and comes down to specific legal interpretations of the Oil and Gas Act and the Reasonable Accommodation Doctrine of Title 34, Article 60, Section 127 of the Colorado Revised Statutes. In full disclosure, I'm not a lawyer, and I've been advised by good counsel not to stray too far into that arena. And so I will leave the arguments about how to interpret or implement this important bit of statute to the bar. What I will say is this: establishing the right to construct and the right to conduct oil and gas operations on the surface land is fundamental to staff's review of a permit application. We cannot approve or recommend for approval a well or an oil and gas location for which there isn't a clearly demonstrated right to construct. And there are several ways an operator may establish this right. The simplest is to own the land. It's my land. If I say I can do something on my land, then subject to applicable laws, rules, and regulations, I can. The next easiest way to demonstrate is a surface use agreement with the landowner that allows for the explicit use of the land. This is a contract between two or more parties that establishes the right to use the surface, and usually for a fee. It's her land, but she agrees that I can do this, so subject to applicable rules, laws, rules, and regulations, I can do this. And the other way to establish the right to construct is by mineral ownership. And this is where the reasonable accommodation doctrine comes in. Basically, if you are a mineral owner, in order to access your minerals, you must be allowed reasonable access at the surface. And again, I'm not providing a legal interpretation here, but just affirming that staff looks for a valid mineral lease for the minerals directly below the surface and for those minerals to be produced by the well or wells being proposed. So now we'll look at a couple examples, and you'll see how complicated this last right to construct issue can become. So what you see here are several parcels of land delineated by the light blue lines in the south half of Section 32 and the north half of Section 5. Section 32 is a single parcel of land, and Section 5 is broken up into several smaller parcels. With this, I will show the world of vertical wells, which, bear in mind, does still happen on a regular basis in Colorado. And in this world of vertical wells, it's not too hard to determine if the well will develop a lease from the surface. So for example, if a lease covers the south half of section 32, then it can be used to establish a right to construct any of the wells within that lease. So all of those wells can be developed based on the lease. Alternatively, let's say a lease covers the west half of section 5 to the south. Again, it can be used to establish a right to construct for those wells in the west half of the section, but not for the well in the northeast quarter of the section. And I'll also mention here that directionally drilled wells, or S-curve type wells, can also be evaluated in the same manner by looking at where the surface is and where the minerals are. So a directional well developing minerals in the south half of section 32 could have its surface location anywhere within the surface reflection of that lease. For example, it could have drilled from one of these twin surface locations in the southwest-southeast quarter to the bottom hole in the southwest-southwest quarter. But again, the lease in this west half of section 5 could not be used to directionally drill over to the northeast quarter. And now I want to take a look at what this means for horizontal wells, which often develop minerals that extend below multiple property owners, and surface land parcels may not always match up with the mineral stake or land lease boundaries. And I believe you learned a ton about this and how this works in the spacing and pooling informational docket presented by Jane Stanzik and John Peskin. But I'm going to show you a specific example where the mineral situation made the right to construct discussion fairly complex. You can ignore the 3 vertical well spots for this, and we're just going to consider these 2 groups of wells here in a different section 32, and sorry about using the same sections for 2 different examples. Again, the light blue lines are surface property lines, so vertically north to south in section 29 and east to west dividing section 32. And the minerals in this area are intact in 640-acre tracts or leases. The surface land is divided into 320-acre parcels. If you look closely, you can see that the rows of wells on each site develop either north to section 20 and 29 or south to section 32 and 5. Just like before, if the wells are on the surface of the overlying minerals being developed, the lease may grant the right to construct. So to the south, they are on top of the minerals being developed. These lower row of wells can be developed. If they are not situated over the minerals, then the lease can't be used to demonstrate the right to construct. So for these down here, drilling to the north, the lease doesn't grant the right on a different surface. In this case, the operator submitted their application with the lease as the sole right to construct. And while they did have all the correct leases in place, since the half of the wells could not be granted the right to construct through the lease, the operator had to seek a surface use agreement in order to perfect their right to construct on the entire oil and gas location. Staff was unable to approve the oil and gas location without a surface use agreement. And then before we leave this topic, I want to mention how a drilling and spacing unit can affect things. In this horizontal example, if the drilling and spacing unit was for the entire area being developed, 1 DSU for 2560 acres, I believe, so sections 20, 29, 32, and 5 all together, the lease in the north half of section 32 would allow for the development of the northbound wells and as well as the southbound wells, because all of those minerals would be consolidated into that one drilling and spacing unit. And likewise, over in the vertical example, if there was a DSU that combined the minerals in section 5, the directional well from the west half could be used to develop the northeast quarter minerals. And Chairman, I can pause here for questions if you'd like, or I can keep moving through my slides. It may be an opportunity for questions.
Yeah, it seems like you kind of wrapped up this one fundamental point, and while you are not a lawyer, you do a good job of playing one on TV, because it's pretty complicated stuff. But I do understand what you're saying. I just want to look to my fellow commissioners to see if anyone has questions at this point before you move on. And I can't see everybody because I've got your screen up. I think I see Commissioner McGowan with a hand raised.
Thank you, Mr. Chair. Thank you, Mr. Drongel. So sorry, I think I'm not grasping something, which is if the minerals are directly under the surface, I have right to construct. But if I'm not the surface owner, I have to have an agreement with the person who owns the surface. If the person who owns the surface does not want a well on their property, are they allowed to say no, even though there's this right to construct because the minerals are underneath that surface?
So thanks for that question. And that is the sort of the rub of the reasonable accommodation doctrine. And that's where we have applied a process called bonding on for that surface. So if the operator has a lease to develop minerals, and they have the plans to use the surface, and they are unable to come to an agreeable terms with the surface owner, they are able to put up a surface bond and access the surface with that bond in place as a protective measure for the surface owner. That part of the statute has not changed to the best of my knowledge. And again, this is where you know, the legal teams would do a better job of addressing that. But the way we have implemented that is through the bond on process. And that has become, I will just add, you know, exceptionally rare over the last, you know, certainly the 10 years that I've been here. It used to be fairly common, and it used to be, you know, perhaps a leveraging tool for obtaining a surface use agreement. And I think more often than not now, operators are just, especially with the horizontal development, they're negotiating a surface use agreement in good faith.
AG Davenport, would you like to weigh in a little bit on this legal issue?
Well, I'm happy to. I think just to clarify in regard to your question, Commissioner McGowan, the reasonable accommodation doctrine is codified in section 3460-127, does allow an operator to conduct operations on the surface, even if the surface owner doesn't enter into a surface use agreement. What the reasonable accommodation doctrine provides in the statute as well is that the operator still has to take into account the surface owner's uses and reasonably accommodate those surface owner's uses. When Mr. Duranlo refers to bonding on, that is the commission's process for recognizing the operator's ability to conduct surface operations, even if the operator doesn't have a surface use agreement with the surface owner. So that's the backup process. If there's no surface use agreement, that operator still has to obtain a bond for reclamation and other things. But the ultimate, the most basic answer to your question is, yes, the operator can still conduct surface operations even if the surface owner doesn't agree, but must still take into account the uses that the surface owner is intending or using the surface for.
Commissioner McGowan.
Thank you, AJG Davenport. So sorry, and I'm really trying not to head down a rabbit hole, but is it then similar to eminent domain where the operator still then has to provide some sort of monetary compensation for using the property even against that surface owner's wishes under the reasonable accommodation?
No, it's not eminent domain. The government isn't doing anything here in this specific case in terms of, when we have eminent domain, usually that's the government taking property or something in that regard. This isn't the same thing. The bonding on process is there to ensure that there is money available at the end of the process to reclaim that property. And that's the reason that we have bonding on. But there is no compensation required by the reasonable accommodation doctrine for a surface owner.
And I would like to add, bonding on is if an operator is proposing to use the surface bond to access the surface instead of a surface use agreement or other right to construct, then that does trigger the alternative location analysis, because the commissioners were interested in saying, hey, look, if you're forcing your way onto one property and there's a willing landowner somewhere else, why aren't we talking to that willing landowner, engaging in a surface use agreement and doing it where someone actually wants that development to happen?
Okay,
Mr. Chair.
Donlow, or Mr. Davenport, yes.
Sorry, I appreciate the ability to say one more thing. The only other thing I want to add is there's a lot of nuance here. Whether or not who owns the minerals directly below that surface estate where the operator is proposing to conduct operations can make a difference. And that's where it starts to get pretty complex, and why I think everyone would prefer a surface use agreement if it is all possible.
Or surface ownership by the operator.
Yes, right.
Very good. Seeing no further questions during this pause, Mr. Donlow, would you like to move forward?
Excellent. Thank you, Chairman. And thanks for the questions. So in the past, that was about all there was to surface selection. I have the right to construct, I'm drilling a vertical well, therefore that's what's happening. But we've come a long way over the decades of development and regulatory changes in Colorado. Where we are as an agency and where industry is today is far removed from the past practices. But that doesn't obviously mean that surface development for oil and gas resources is not without conflict. And that's not unlike any surface development for any other purpose. So let's take a look at some of the surface constraints that will drive site selection. And again, I'll try to paint a picture of how that's connected to our permitting process. The first constraints that may be encountered are the physical constraints. Topography can obviously play a big role, especially in the mountainous regions of the West Slope, but minimizing cuts and fills is an important consideration on the Eastern Plains as well. Any selected site must provide logistical access to the minerals. Operators are bending miles of steel pipe underground and must be able to reach their target and build their well. The technological advances over the last couple of decades have been nothing short of amazing, but it still does not mean that all things are possible at all locations, or because it could be done at one well, it will work at every other well. And operators must work around existing infrastructure, including roads, railroads, airports, pipeline right-of-ways, rights-of-way, overhead power lines, and so many other things that we take for granted on a daily basis. Next would be the environmental considerations. And I'll start with the human population as the most significant environmental receptor. People will always be at the forefront of the planning process for siting. So operators and COGCC are evaluating residential development, neighborhoods, schools, childcare facilities, and now factoring disproportionately impacted communities into this calculus. Other significant environmental receptors include surface water resources, wildlife resources, soil and vegetative resources, groundwater resources, and so many more. And then, but no less importantly, are what I would consider to be administrative constraints. Local governments, both relevant and proximate, will need to be considered. What land use permitting is required, and what restrictions may be in place. Surface owner negotiations will be another big consideration as we talked about. And some surface landowners are very receptive to oil and gas development and others are not. Obviously, negotiating with a surface use agreement with an unwilling landowner could be an exercise in futility. So now we're going to walk through an example, and this shows a few square miles south of Rifle. So you'll see how so many of these factors play across the landscape. First, the topography shows a fairly flat, high mesa with steeply incised, canyons down to stream bottoms, and then the Grand River Valley at the north. So cuts and fills and road construction may be a significant factors for an operator to consider if they're planning development here. Mineral access is primarily through S-curve directional wells, so reach and torque and drag for drilling and pumping equipment will need to be considered. The interstate and roads, local roads, airport, the city of Rifle are all significant infrastructure considerations. And the population center of Rifle needs to be considered as well as not only in the city of Rifle, but also rural residents south of town. And the some areas along the Grand River Valley are classified as a disproportionately impacted community. In addition to the streams in the drainages, there's a Rule 411, Public Water System Surface Water Supply Protection Area to consider. There are wildlife habitats, including a no surface occupancy area along some of the streams and general big game density determination habitat throughout the area we're looking at. Administratively, there are lands managed by both Garfield County and the city of Rifle. And then after considering all that, the operator must look at the parcels and identify a surface owner that would be willing to negotiate with them for that activity. And I show this example with all these overlapping constraints to emphasize that it will take careful planning from the earliest inception of a project to achieve a successful outcome at the end. It's very rare that we're going to find areas where none of these issues come into play. I will try and come full circle back to that end that we previously had in mind. How does all this fit in and get communicated through the COGCC application process? At its most basic, the COGCC application is a communication tool. With it, the applicant operator uses the data fields on the Form 2A, the drawings and attachments, the required plans and best management practices as tools to convey their strategy for development. COGCC considers the alternative locations analysis, the entirety of the oil and gas development plan, the cumulative impacts data, and information from local governments, consultative partners, and public comment as part of our technical evaluation of the proposed surface location or locations. And if all goes according to plan, staff and the director will find that the applicant has demonstrated that they can safely and effectively complete the mineral development from their proposed location, that the thoughtful siting, operational practices, and quality best management practices demonstrates the operator's commitment to preventing adverse impacts, and then the director can make a recommendation to approve the development plan. However, staff may find that despite an applicant's best efforts, the operator's siting selection process did not arrive at the apparent best location, or that the best location was selected, but the practices are not sufficiently protective. In those cases, staff may continue to work with the applicant to determine if we can reach a better outcome, or staff may recommend the commission deny the application. And regardless of the outcome, a well-documented and robust site selection process is absolutely crucial to the integrity of the oil and gas permitting process. COGCC's alternative location analysis process is one, but not the only resource for operators to use in this process. And there are a vast number of constraints that will need to be considered for each and every proposal. And with that, Chair Robbins, I can take additional questions or turn it directly over to the industry panel. And I thank you again very much for your time today.
Great. Thank you, Environmental Manager Duranolo, for the overview from staff's perspective. I think that's helpful as we have today's informational sessions. Looking to see if we have questions from commissioners at this point for you. Okay, I'm not seeing any. So with that, I actually would like to call upon Commissioner Gonzalez, who put together the next panel, and perhaps allow him to introduce the panel for us at this point.
Sure. Thank you, Mr. Chair. So we're going to have a panel that consists of 6 operators from both the Front Range and the Western Slope, and we've broken that up to have that equal representation and understand some of the nuance and some of the considerations that are impacting how these operators go about their business in their respective operating areas. The Front Range, the DJ Basin operators are going to go first. That includes Occidental Petroleum, Chevron, as well as Crestone Peak Resources. And we've got Ryan Antonio, Bob Bresnahan, Don Job, representing those organizations. Subsequent to their presentation, and we'll probably have time for questions in between, we're going to hear from operators from the West Slope, including Caris, Terra Energy Partners, and Laramie Energy. And so we'll hear from them in a bit. And with that, I think that the Front Range operators have kind of organized this presentation themselves and are going to coordinate how that goes. And I will turn it over to the panel to begin.
Good morning. We are bringing them on board.
And Mr. Chair, for the record purposes, I believe Mr. Job is starting first.
Yeah, thank you, Mr. Gonzalez. Yes. Good morning, everybody. Let me, can everybody hear me okay?
We can hear you. We cannot see you, which is fine, but just so you know.
Oh, okay. Turning my camera on now, and let me see if I can get my screen to share.
Okay, just for the record, you turn your camera back off.
Let's see here.
You might, yeah, I think you want to share your PowerPoint screen. Right now you're sharing a screen of all of us. There we go.
Can everybody see that okay?
Yes, we can see that. Great. Thank you, Mr. Job.
Okay, great. All right, well, we appreciate the opportunity to meet with you today. Again, my name is Don Job. I'm the surface land manager at Occidental Petroleum for our Rockies asset. We're looking forward to present with you this knowledge share of surface siting processes, challenges, and constraints our companies work through, both from the rural areas and to the urban corridor in Colorado. As competitive land use increases here, we understand the importance of siting wells and facilities combined with the best management practices to protect public health, safety, welfare, and the environment. So for the next 30 minutes or so, my colleagues, Bob Bresnahan with Crestone, Ryan Antonio with Chevron, and I will be walking you through some of the challenges and constraints that we identify when siting wells and facilities. And we'll transition to how this applies to the alternative location analysis process. We'll share with you the interaction and relationship we have with developers when siting wells and facilities. And lastly, share the importance and the process of surface owner engagement. So if you have any questions, you know, it'll more likely be answered during the presentation, but feel free to interrupt us and ask. We have numbered each slide, so if you want to also write down the slide number, we can refer back to it at the end of our presentation during the Q&A portion of our time together. So with that said, let's jump into this, and let me make sure this is working correctly. There we go. And walk through an exercise of a section of land that at first glance looks promising to site well pads and facilities with large open spaces of land. As we walk through this exercise and highlight some of the surface constraints, setbacks, and other restrictive components, our outcome of what we first glance appears to be a promising area or section might need more consideration. And I'll preface this for this exercise that we're developing this area for horizontal development, horizontal wells, and we'll consider the operator owns or has leased all of the mineral interests in this section. So one of the first layers, as Mr. Darnlow had talked about, is when we site wells and facilities, or property line setbacks. Per Rule 604, setbacks from a property line without an offset property line waiver from the adjacent surface owners, 150 feet. So immediately we understand how the lands are divided, ownership of lands, which moves us into the process, our due diligence phase of our review process, and looking at existing underlying agreements in the area. So with the due diligence phase, we identify those agreements that have surface constraints in one form or another. These constraints come in many forms. However, all of these restrictive agreements restrict the access, use, or even timing of the operations on the lands they cover. So whether it be a no surface occupancy lease, as shown here and here, or a surface use agreement with a developer, wells have been drilled and now homes are built around those operation areas. Some agreements have operational timeline restrictions that don't necessarily limit access, however, will limit when we can drill and complete these wells. So we see how the underlying restrictive agreements affect this section of land when we evaluate the surface. So the next area, we perform an environmental evaluation and identify undevelopable areas. These areas include bodies of water, rivers, streams, ditches, areas with high groundwater. We do a groundwater analysis, which affects the grading plans of a pad. So we take that into consideration. And during this step in the evaluation, we also will perform a floodplain assessment, look for floodways, floodplains in the area, not necessarily undevelopable, but higher BMPs, and we do like to stay out of floodplains. Again, as Mr. Darnlow spoke this morning, people and where they live, work, go to school are at the forefront of siting evaluation. As we can see here in the example per the Rule 604, we've placed 500-foot buffer around the surrounding homes in the area, where a working pad surface cannot be placed unless an SUA or a waiver is executed, including informed consent for all building unit owners and tenants explicitly agreeing to the proposed oil and gas siting. So per the Rule 604 as well, if there were any schools or daycares identified in this area, the working pad surface would need to be 2,000 feet away from those school facilities or daycare centers. The next area of surface evaluation involves riparian setbacks and high priority habitat areas. The yellow buffer, circle buffers you see are a 500-foot setback from raptor nests. In this particular example, there's a high priority habitat area. The large yellow triangle area you see is a mule deer corridor, a migration corridor. And although it might not always be completely restricted in these corridors, these high priority habitats, there may be compensatory mitigation involved if the wells or facilities are sited in these areas. So we definitely have to take that into account. So as we move through and complete the due diligence phase of looking at agreements, restrictive agreements, and evaluating the underlying easements in the area, we understand the existing infrastructure that will limit the placement of well pads and facilities. But not only do we need to understand where the infrastructure is located, the agreements within themselves, the rights of way, so on and so forth, will have setback restrictions as showed in the red buffers here. The wider setback going east and west and then north is the 200-foot setback for overhead power lines per Rule 604 that states at the time of a well is drilled, A well will be located no less than 200 feet from buildings, public roads, and above ground utilities or even railroads. So we must keep in mind and work with surface owners regarding also their private utilities, water drain tiles, and other buried infrastructure such as private water and electrical lines. So with any surface owner we work with, we must consider a balance of their property rights, enjoyment of their land, their livelihood, how they make their money with their land when working with them to site wells and facilities. So as shown in green here, there are a couple of areas where we have pivot irrigated crops, as well as there are some other areas you can see with some lines, well, probably not anymore, but where wells where land is flood irrigated crop. And that's not even highlighted there. So although it's not impossible to site wells within pivots or irrigated crop fields, we do take this into consideration when working with our surface owners and the use and enjoyment of their land. And finally, outlined in gold here is the local municipality boundary. We as operators understand and know it's important that when we site wells and facilities to engage not only with the towns and municipalities we're planning to operate within, but also the surrounding stakeholders in the community. Early involvement and engagement are key to building this working relationship with our stakeholders and our surface owners and the people we work with within the municipality boundaries. So finally, after evaluating the section of land, we could potentially move forward with the 4 locations highlighted in purple. There may be a couple of others that may require more BMP or even compensatory mitigations, but although we could also consider further evaluating locations in the southwest portion of the section with, you know, the proximity to the river, high priority habitat, wetlands designations, we determined more likely there are other favorable locations to choose from. So this exercise emphasizes that the increased competitive land use and encroachment to open space is shrinking potential drillable surface acreage at a high rate. So out of the possible locations assessed in this section, there may even be other alternative locations within the greater area that could be determined even more favorable than these 4. I wanted to make sure that Bob is on right now. Does anybody have any questions at this point?
Mr. Chair?
Yes, sorry, Commissioner Gonzalez, please.
Yeah, I wanted to kind of chime in here and say, you know, when we're looking at this, Mr. Job, this looks like just an alternative location analysis as we've kind of contemplated to some extent. Is this something that's done regularly? Is this something that's done as a result of those rules?
This type of surface evaluation was done even prior to these rules. The alternative location analysis was put into place.
Could you talk
Yeah,
about,
so
go ahead.
We look at all of these constraints, you know, for every section of land and any area we're going to have wellbore space units or DSUs.
Thank you. Could you mentioned a term, a no surface occupancy lease. Could you tell us what that means and what other types of surface restrictions may or may not occur in a lease form?
Yeah, so you know, no surface occupancy lease is outlined in a mineral lease, and it will just highlight and have language that there is a restriction to surface access for the lands that it covers. And so while there's not, you know, while we always think, well, if we have a lease, then we may have a right to access to construct. Within some of those leases even have a no surface access as well. Some leases also, like I had mentioned, will have timing restrictions. So even though we do have access, it could get very complicated with even timing because some of these leases were put together with crops in mind. And so the timing of those operations outside of crop planting and harvesting are something we also have to look at when we evaluate these underlying agreements.
Thank you.
Sure.
Mr. Joe, before you move on, if I could ask a couple of clarifying questions. So I'm looking at your sort of different colors here. I'm also hearing feedback. I wonder if that's me. Anyway, so it seems like some of the colors or some of the restrictions are kind of hard no's. So for instance, the property line setback at 150 feet. That seems like that's a hard no. But as I look at the underlying restrictive agreements, that was a negotiated no on the part of the operator and the surface owner. Is that right? Because that's part of a negotiated SUA. You're muted, Mr. Job.
Sorry about that. Hear me okay?
Yeah. Testing 1, 2, 3. Let's see if we can hear you.
My connection's bad.
Yeah, you appear to be frozen now, Mr. Job.
Hey, Robbins, this is Ryan Antonio. I could jump in. Question
Sorry
if you
about
can
that.
hear me.
Yeah, I can hear you, Mr. Antonio. Do you want to jump in? I'm sure you're familiar with this line of inquiry as well.
Yeah, so to answer your question, there are some leases out there that have no surface occupancy provisions that were negotiated as part of the original lease. And typically, those are mostly in residential lots that have mineral ownership in some of our towns and municipalities. So it's typically something we would agree to, because we would never intend to, have a drilling operation in somebody's, residential lot in their backyard. So that's where those are the most common, and that's kind of shown in that red layer on Mr. Job's slides there.
Yeah, what about that area that is below the right-hand purple dot that is not residential? At least it doesn't appear to be residential.
Can you see my right here?
I think just north of that, Don.
Oh, right here?
Yeah, that area.
Yeah, I mean, it may have just been a surface owner that may not, or a mineral owner that may not wanted to have any surface access, but entered into a mineral lease. And some of these restrictive agreements, we may have acquired these agreements, or it was the only way to lease some land. So, and just by looking at the surrounding areas, we made the decision it was okay to go ahead and move forward with a no surface occupancy lease. However, it's definitely not standard.
Okay, thanks. I'm just trying to get perspective on this. And then there are a couple of the other constraints that you've highlighted, such as the riparian or the high priority habitat. And again, for instance, the mule deer migration corridor, you could actually go there, right? Have to use compensatory mitigation. So that too is not an all-out no, even though it is highlighted as yes. Am I correct there?
Yes, sir. And that's what I kind of highlighted towards the end. It's not a hard no there. There might be some more BMPs. We're close to the river there, and they're just other. And like Bill said, you look at alternative location analysis at that point, just an evaluation, and say, we could go there. We could propose this to the commission, but are there other areas that look even better? And so, while it's not a hard no, we try to stay out of those areas, although, in some cases that might be the location that we're presenting as well.
Okay. That was kind of
Yeah.
what I was getting at, is it's a balancing and a weighing. And what I appreciate is that what your surface land site planning and execution, it syncs up pretty well, in my opinion, with the alternative location analysis rule that was created. And so you're kind of already there a little bit.
Yes, exactly.
Mr. Chair.
Yes. So
Commissioner Messner.
Thanks. Are we still good asking questions here? Okay. So I appreciate the presentation. I did have just a few questions. So before this analysis is even done, one of the questions I have is, what's the process for initially reaching out to potential surface owners to determine whether or not there might be a viable agreement worked out with them, kind of that initial step before determining, before putting these layers in place, I guess.
Yeah, thanks for the question. I think in many cases, we will run through this analysis for the most part, even before we reach out to the surface owner initially. We will, because we want to make sure that we're not encroaching or asking to put facility and pads on a location where, if we go back and within our due diligence process, we find that there's a no surface occupancy lease or a right of way or something that would restrict access. We want to make sure we have all of those items in our tool belt to understand the area first. And then a lot of this is when we go to a surface owner, we'll have a good idea of what might work with the new rules and the setbacks and these underlying agreements. When we first make that initial meeting, we can have a good sense of where a pad could be located.
Okay. Thanks for that. And then, I noticed one of the sites in here is in the middle of an irrigated circle. Do you typically look initially to site these facilities in the corner of these circles, or is it common to choose sites within that irrigated agricultural circle?
No, for this exercise, it was, yeah, and you're right. We will work with the surface owner. I think if you see here, obviously we have a 200-foot setback. I don't know if you guys can see my
I can see it, yeah.
My cursor, but there's a tank here. I think there might have been some low areas here, and so we will definitely look at trying to get outside of the crop circle. It's really hard to do that with the actual pad location. It's going to affect. So just for the exercise, I set it here. It could be more up here, and Ryan is actually going to show a really good example of how we worked with the surface owner within a crop circle as well during the latter part of his presentation. That'll really highlight this.
Okay, I appreciate that, and I can wait with some more questions about that until Mr. Antonio gives his presentation. Couple other questions. So, you're initially starting here with a 500-foot setback consideration from residential building units, which is certainly one way to look at it, understanding that you would have to utilize the off-ramps that were developed in the rules in order to be able to get between 2,000 feet and 500 feet of residential building units. You've also got a setback in 604 that's a hard setback of 2,000 feet from schools. Why would your initial blush only have that 500-foot setback instead of that 2,000-foot setback to see if that was a feasible option?
Yeah, and in many cases, we'll have a larger area that we're looking at. We're looking at the entire DSU or even the surrounding sections to really put that 2,000 foot buffer on building unit setbacks, to see, you know, how many of these building units will be within that 2,000 foot buffer. And so there, you know, I would just say, John, for this example only, I put that on. I could have, you know, put on a 2,000 foot setback around all this. It would completely cover the entire map, obviously. And that's where I think the alternative location analysis comes in. And you would then move north or south, depending on your orientation, and you would look at those areas where it might be less, you know, less engaging with those building units.
Okay. And then last question. So I appreciate the considerations around different, you know, setback and land uses pre-drilling, but is there any considerations for what future anticipated land uses could be in doing your alternative location analysis? So example would be there's clearly a, you know, a subdivision and a municipal boundary. In this particular example, it could be anticipated in consultation with the local government that that may be a future land use there could be housing or subdivisions. Is that part of any initial consideration here?
Absolutely, and thanks for the question. I think Bob's going to go into that a little bit more with working with developers. You know, we get development notices from different municipalities all the time regarding surface development of lands, and, you know, engaging with those developers is key. Engaging with the municipality on their growth boundaries and what they are designating land use within their towns, and so that's all a part of the evaluation as well. And it's important to engage early and often in those situations, for sure.
Okay, thank you.
Thank you.
Mr. Chair.
Commissioner McGowan.
Thank you. And maybe I missed this at the beginning of your presentation, but are we assuming that this is potentially horizontal drilling? And if that's the case, then some of the locations that might be considered might be outside of this boundary if you have a willing surface owner?
Yes, absolutely. Yeah, this was a consideration for horizontal development. Yes.
Thank you.
Welcome.
Other commissioners with questions before we move forward? All right, seeing none, Mr. Job or Mr. Antonio, if you would like to move forward, we appreciate it.
Yeah, I think we're going to turn it over to Bob now with Crestone Peak, and I'll run the slides for us here, and I'll let you take it away.
Great, thank you, Mr. Job. Commissioners, appreciate the time. Right here, I'm going to go through an example of kind of DJ urban pad development that we did. Keep in mind that this was previous to the Senate Bill 181. So as I go through this, you'll see how even many years ago, we were going through an analysis that we're now actually documenting and providing as part of our ALA. So right here at Crestone Peak, generally speaking, geology or mineral land will request development of certain areas of leasehold acreage. What you see here, anything in yellow is the area that Crestone Peak Resources had leasehold, and this is the area that was being requested to be developed using the stand-up or north-south directional well bores. So we see in section 6 in the southwest quarter, there's some leasehold. In section 7, there's quite a bit of leasehold on the north, a little bit on the south. And then in section 18, you'll see some yellow leasehold that's wanting to be developed. This slide again shows the area that is trying to be developed. In gray, you will see that's the town of Erie, annexed into Erie. On the west side is Boulder County, and on the east side, where the red actually is, that's actually in Weld County. So we identify different counties and municipalities that we're going to have to be in contact with. Obviously, post Senate Bill 181, it's even more important. It's important for us to assess what other agreements within the development area we're going to have to abide by any operator agreements, and then also just understand really what the municipalities and the counties are going to require of us consultation-wise and as we move forward with the development. So we want to first identify possible surface options and surface owners where our current leasehold exists. And then we also identify other surface options that maybe we don't have leasehold. So we need to identify what operator may have that leasehold and an opportunity to possibly use that surface and negotiate an agreement with them. We obviously look at our internal departments, look at schools and childcare. It's really critical in these areas for schools and childcare because we do have the 2,000 foot setback, obviously. We look at building unit owners, waterways, floodplains, the riparian. We also look at ingress and egress and how that is going to affect traffic flow if we have high traffic areas. We identify locations that already have existing oil and gas operations. If we can consolidate, then certainly we look forward to doing that. And then at a kind of overview, we approach our different teams, our construction team, drilling, completion, production teams to make sure that the ability to utilize that location to develop the leasehold is technologically available. And we also look at existing land use, planned land use, current zoning, what may or may not be required to be rezoned for our type of development. And then again, as Mr. Job went through a lot of these, we also look at different leases that may or may not allow surface development, existing SUAs over lands and locations. And we just try to identify other surface restrictions, such as pipeline right-of-ways, railroad right-of-ways, and those types of things. So from that, we identified Section 6 as a possible location to develop this leasehold from. The next slide shows a little bit up close. So here we go, Section 6. In the northeast quarter, you can see there's quite a few homes and residential areas. On the south end of that northeast is actually owned by a developer who has a planned development there. The southeast quarter is also owned by the same developer that has a residential plan developed there. We also have no leasehold. That was another operator that is under an existing SUA with that operator. The southwest quarter has homes and ditches running through it that make it not accessible for horizontal drilling. So it really leaves us with the northwest quarter. That's bounded by County Line Road and Highway 52. Ingress and egress allocation would be very challenging. In addition, that is not leasehold held by Crestone, by a different operator. And which makes it most challenging, or was it's actually land that's owned by Broomfield. So the likelihood through our discussions of getting an SUA on that land was very, very limited. So those challenges made us look further. So then we evaluated Section 18 down south to drill going north to develop the minerals. As you see in the northwest quarter, southwest quarter, pretty densely populated, very limited options there. So you look at the southeast and the northeast, say, hey, there might be some possibilities here. The southeast quarter, there's a little bit of development going on there. There's a railroad right away, and that's highlighted in red, actually. So we have a setback from the railroad right away. We have a cemetery in the northeast quarter that would limit our ability to do any drilling and development from there. And also there's a couple high pressure gas lines that run right through the middle of the northeast to the southeast, going north and south. So as you'll see what we did, this is the same section. We overlaid it with what actually some approved development plans are in the town of Erie. And as you can see, the residential development encroachment on any possible locations was something that we didn't look at in a positive nature. And we really wanted to see if there are other opportunities to avoid this location. So we looked at the possibility of developing minerals and from section 7, which would be drilling south to develop the east half and north and south to develop the west half. As you can see here, this is section 7. In the northeast quarter and the northwest quarter, we have locations identified that are actually our development locations from S-curve drill wells or vertical wells. In the southeast quarter, pretty much all residential development. And then the southwest quarter, there were some possible capabilities to drill from there. Again, we have the residential development kind of in the northeast corner. And then actually to the west of this, there's quite a bit large development in the town of or in Erie, but in Boulder County that we're also trying to avoid. So we identified the northwest and the northeast quarter and the possibility to develop from here. In the southwest of the northwest was a location that we identified. It's an existing location, so we looked at the possibility of expanding that. That is in a floodplain. It is in actually unincorporated Weld County, this little section is. It is close to a ditch, but we looked at the possibility of all else being equal, the ability to P&A the well and to expand that location for development. We looked at the central location of the northwest, what has an existing location. I'll get back to that. And then the northeast quarter, we find 3 locations that were already being utilized, and we identified these as possible developments. So what we did is then we took this information and we approached the surface owner and the developer to begin discussions at least of what possibilities there are on this land, what the future plans are for this land. And what we can do to consolidate locations and minimize tank usage and the possibility of beginning production prior to any development of this land. So during our discussions, it looked like things were going to be positive for the developer and the surface owner. So of course we engaged the town of Erie at the on-site also. And then we started to identify neighborhoods that would be affected if we were to move forward with this plan. And we began to outreach, our community relations team began to do extensive outreach to these affected or possibly affected communities. So the neighbors to the south and the southwest, their main concerns were, of course, traffic, noise, and light. And then on the east side, we had the Erie Air Park and their concerns around that's their runway that's being circled there. Thank you, Don. And they had, of course, concerns with where our rig would be, how tall our rig would be, any lighting concerns, and then traffic mitigations. And then we did have a neighbor to the north, kind of northeast corner, one small neighbor there. Of course, we were very diligent in communication with that neighbor for not just the possibility of development, but also we were looking at this point in time, we were starting to look at the installation of gas pipeline, produced water pipeline, and oil pipeline to thereby minimize even further our effect on the communities with truck traffic. So we started to move forward with our discussions with the surrounding neighbors and with the town of Erie and with a developer and surface owner. We started to move forward with the possibility of developing the northeast pad, the southwest pad, and then utilizing a central completions pad. Sorry, these pads are a little off kilter. That completions pad is supposed to be closer to that existing facility area down there. Thank you, Don. Yep. And then that northeast pad is a little bit identified as it should be a little bit further south, so it's not right on top of that home. So we moved that as close as we could to the property line with discussions with the neighbor to the north to get it out of the runway emergency landing pathway for the air park. And as we also put in some BMP practices to minimize our lighting and the direction of our lighting during drilling and completions phase. So we're getting drilled from two different pads, the northeast pad drilling south to develop the minerals, the southwest pad drilling north and south to develop the minerals. And then what we can do is put a central completions pad. The topography is actually up higher. It's away from communities. There you go. Thank you, Don. Appreciate that. And that would allow us to complete both pads from one central location. We would pipe the completions fluid from that central pad to the east pad and to the southwest pad. And that way, kind of centralizing all of our activity on one middle pad furthest away from the communities. This shows again kind of how we developed it. On the left-hand side, you'll see a map again of the yellow leasehold that was being developed. And that was developed north and south from the southwest pad. And then the northeast pad developed minerals going south 2 miles. Then on the right-hand side, you'll see this is how we worked with the developer in the Towney area to kind of get our locations outside of their development, their planned development. And then we also agreed in our agreement with the developer to P&A some of the old S wells or vertical wells so they could open up the middle area for our Central Park area. And then kind of the southeast corner, they could, at least from Creston's point of view, they could utilize that area for green space also. The completions pad up there in the center, it also has red in it because it has existing wells. There's actually a planned park walkway through there, and it's also a kind of corridor to get a water pipeline north and south. So that was kind of taken into consideration during our discussions with Erie and the developer on not really using that area and having that kept open as a green area. And eventually those wells, you know, when their economic life is through, will be P&A'd, and that will be complete open space also. So I also wanted to pinpoint kind of, again, the P&A of some of the wells that we agreed to. Also, the developer was able to put metro districts around our wellheads. And what that allowed him to do is the metro districts around the wellheads bring in a taxation on our wellheads that he can then use to develop his infrastructure, thereby moving forward with the development quicker and kind of working hand in hand with him and the town and developing this area in our leasehold. And we were able to accomplish it prior to any construction beginning of the infrastructure. We could plan our pipelines that were going to each of the pads and taking the fluids away from the location. We could plan those at elevations that were final elevations for his grading. And we could also work with him for his different detention ponds around our facilities to help accommodate his development. And this is pretty much what it looks like currently. In the northeast, you can see a small pad that has our separators and our wells and a detention pond around that location. We're kind of in a peninsula. He can use that area as his required detention pond. You can see the homes being developed and the infrastructure being developed. And then in the southeast quarter, you can see, again, our facilities and wells, our southwest quarter, our facilities and our wells there. Again, we added pipeline in here. The oil and the gas, or the oil and the produced water, are piped off location into an area called our hub location, which is a centralized gathering facility for this Erie area. And it's about 3 or 4 miles away from this location. And that concludes my brief presentation on the urban development working with the towns and municipalities and the developer to develop a leasehold and get his development in. I'd be happy to take questions if you have them now, or we can wait.
Commissioners, do we have questions? Commissioner Messner?
Thank you, Mr. Chair. And thank you, Mr. Bresnahan, for the presentation. I think it was a good example of the considerations that go into this. I did have a couple of questions. So, I mean, I think it was an interesting concept to have a central, completions pad. I didn't totally catch, though, once the completions were finished, does that pad go away then?
Yes, Commissioner. Yes, it does. As you can see in this picture, the central facilities pad is kind of up in the northwest. You can see some tanks up there. That's actually the tanks for the existing, yes, thank you, Don. That's tanks and wells and facilities for existing directional wells. The completions pad, you can see Don is kind of highlighting right there.
Got it.
That is where the completions pad was.
Okay, and so then that gets reclaimed to whatever the agreement was with the developer. And then the other question I had is, in this particular instance, in consultation with both the developer and the town of Erie, did the developer already have this development approved by the town of Erie prior to Crestone engaging with the developer, or were there conditions of approval put on this development by the town of Erie, or how did that interaction work, and what was the timing of that?
Yeah, and we worked really closely all kind of at the same time. The developer had, so it's a little complicated. I didn't want to get too far into it, but the surface owner was under contract with the developer for many years to develop this land. So the surface owner also had the minerals, but the developer did not have the minerals. The developer had interest in the surface to develop it. He did not have a complete plan put together. We got in contact with him, or were in contact with him on the earlier stages, so we could all work together to maximize everyone's interest, if you will. And then the developer, of course, had interest, understood that we had certain surface use abilities that he wanted to work with us to make sure that his development plan could move forward without objection to us. And then he did reap the benefits and continues to with the infrastructure taxation over the metro district around our wellheads, which is pretty important in some of these development areas.
Okay, and so the town of Erie understood this relationship between Crestone and the developer in approving this particular development and any conditions of approval associated with that?
That is my understanding. A lot of this work, or some of this work, was happening prior to Crestone. So it was, Encana was doing some of this work too. My understanding is, yes, that is the case. That certainly Erie was very well aware of all of our operations and the developers' operations. They obviously had to go through the approval of this, and the operator agreement with the town of Erie was passed on to Crestone.
Okay, thank you. And I wasn't trying to pick. I was just trying to highlight that relationship between developer, operator, and local government in these scenarios. So. Yeah,
no, and I appreciate it. Commissioner, this is a situation where it really kind of identifies how things, if done properly and if done in a timely manner, can work. And I think it turned out it's a positive thing, I think, in this instance.
Thank you.
Commissioner McGowan?
Thank you, Mr. Chair. And I think just to piggyback onto what Commissioner Messner was asking. So and you might not know the answer to this because I think mostly it's probably the developer, but you know, it looks to me like you finished your work before this new development came into, it's starting to get developed, but do you know if and how those plats have been noticed for the neighbors who are moving in? So they know what that is, you know, what these oil and gas sites are and the fact that they've been developed?
Yeah, I think that'd be a question more for the developer on what notifications he has and stuff in place. Yeah, we were drilled and completed, and then he started his development. It was platted well before, but he didn't actually start the infrastructure and start the actual building of his sales offices until more recently after we had already been in place. I do not know what type of notifications that he provides those neighbors.
Thank you.
Other questions from commissioners? Commissioner Messner?
Thank you, Mr. Chair. Sorry, I had a question. And this, I think it applies to probably all the presentations here, but and so I'll just ask it and anyone can answer it. But I'm curious now about as you're doing these analysis and you know, particularly in areas that may be around population centers or subdivisions, and understanding that one of the potential best management practices that could be utilized include electrification. What type of considerations are giving in these location analysis around the existence of you know, electrical grid to be able to tie into to promote additional electrification of either completions or whatever operations would be appropriate for that utilization?
Yeah, no, that's a really good question. I appreciate it, Commissioner. We certainly, especially in these areas, that's one of our main considerations, especially with our air analysis that are going on, and yeah, and all of the facilities that are involved. We take that in consideration, and every operator is different. Every location is different. We always need to keep that in mind. In many of the instances, there is grid availability or the possibility of getting grid power to our locations. And whenever possible, Crestone Peak makes that a priority. We can't always commit to that because it really depends on what kind of loads they're seeing. Sometimes it also depends on what other activity is going on with other operators or other developments in the area. But it certainly, for Crestone's point of view, is a main consideration. And I'm glad you brought that up. I appreciate it.
Thank you.
Thank you very much for the presentation. Did Mr. Antonio, is he going next? Are we going to hear from him?
Yes.
I'm ready, Don, if you want to go to the next slide. So really what I'm going to cover is more specifically our engagement with surface owners. I think Don and Bob did a great job covering the alternative location analysis and how we work with developers in populated areas. So I'm really going to just focus on how do we work with the surface owner and the surrounding residents throughout basically through the life of a well. And just wanted to point out too, our relationships with our surface owners, you know, we view those critical to our current plans, but also really to our future. We want to maintain that social license to operate. We operate in large areas, but really the communities in which we operate are very close. So having a good relationship with the community is important to us, and that's done by how do we do business and how do we treat our surface owners as well as our surrounding residents. So we really want to do it right. We view it as we're entering into a 30-year relationship with the surface owner once we've done our alternative location analysis and we've identified some sites, and also with the surrounding community. Really, the surface owner is engaged through the planning phase as part of the SUA negotiations and the pad siting, all the way through operations, subsequent operations, and into final reclamation. So there's a lot of communication. It depends on surface owners. Some surface owners, we have large ranchers who have hundreds of wells on their ranch, and we have some surface owners who might have 1 or 2 vertical wells. So it depends for each owner, but there's a lot of surface owner engagement just on a day-to-day basis. As Don and Bob touched on, we have residential, commercial development. We have competing land uses there. Also with agriculture, ranching, and land conservation programs. And really what we're trying to do when we enter into when we start talking to our surface owners is we want to minimize conflicts and coexist, with the land use and the surrounding property per the rules. And we have always done it. We have a lot of situations where we have surface owners that may have a lessee or a tenant farmer that may live out of state. That's fairly common. So we work with tenant farmers and really everybody that's impacted by our operations very frequently. Surface owners are usually private property owners. We do work with the Colorado State Land Board. They're actually one of our larger, Chevron's larger landowners in our operating area. We work with the U.S. Forest Service up in the kind of the Pawnee Grasslands, New Raymer area. And we also work with municipalities. City of Broomfield owns land in our operations area, as well as the city of Thornton. So the negotiations might differ. They may be unique. The permitting process is generally the same, with the exception of federal owned surface, which I know we'll cover probably more detail on our West Slope operator group. Don and Bob touched on this. Alternative location analysis due to the onset of horizontal development has been standard business practice, and its operators want to select the location with the least impact to the surface owner and also to the surrounding community. SUAs are key deliverables, and the COGCC rules and the rules of the local government, in our case, Weld County, highly incentivizes operators to enter into a surface use agreement. So we work as best we can, and in most cases we're successful. So surface use agreement is very important to us. I also want to mention too that engagement with the local government, with the COGCC, once we have a location early in the process. I know that's the case in Weld County, where they have a formal pre-application meeting. I think it's really important that we really kind of get a thumbs up at the early planning phases. That gives certainty not only to operators, to the agencies, but also to our surface owners and surrounding residents. And I'll touch on that a little bit more in my next slide here. And also wanted to point out too, there's some COGCC rules that are in place, and I'm not talking ones that would be a threat to public health, safety, welfare, environment, like reclamation rules, final reclamation. That sometimes can cause us conflicts with our surface owners. And just a kind of general example is where we have surface owners that want to, say, a lease road to a well that's been there for 30 years left in place. The rules require us to remove and reclaim the road. So we do have a backlog of reclamation waivers with our surface owners. So we're hoping at some point we can work with the COGCC to come to some solutions there. But those can cause some conflicts, and sometimes it doesn't go over well with our surface owners in those situations. Next slide, really to cover, this is the planning and permitting phase. And just to point out, this happens probably 9 to 12 months before you would even see a permit. There's a lot of work that takes place kind of in the background before we would file a Form 2A or a local government permit. So there's a lot of work done there. The operator at this point in time, once we've done our location analysis, discusses the plan with the surface owner, and there's a lot of details that go into it. But we have to make sure that we cover our access, our pad size, facility placement, any mitigation measures. We have stormwater requirements. We have drainage standards that Weld County has for their requirements. So we really need to make sure that while we're working with the surface owner, that we have enough room, to comply with the rules and regulations. As Don and Bob touched on, we work with local governments. We utilize public information, and oftentimes the best resource for future land use is a surface owner. If they have plans of development of their property, they're oftentimes a good resource and have some knowledge not only of their property but the surrounding properties. One thing that we identify that Don touched on a little bit is private utilities, especially when in agricultural areas. There's drain tiles that have been there for some cases 50 plus to 100 years. So we have to make sure that we address those issues. We have electrical lines and all kinds of private utilities that are considered in our pad placement. So as we're negotiating our SUA, we need to be cognizant of that, as well as along with all the other considerations. For CAPs and other large-scale development plans, we hold community meetings, town halls. There's a lot of engagement with the surface owners and surrounding residents, and we try to take all that feedback in and really make the site the location that we think is going to be successful, that has the least impact. One thing that goes over really well with our surface owners and our residents, if there's potential removal of existing wells and facilities associated with the new development, that's something that we get a lot of good feedback from our surface owner, as well as the surrounding residents. And that's usually the older vertical wells and production facilities that are scattered out there. So that really is a benefit to our community there. In some cases in our OGDPs, we have not only, we might be dealing with more than one surface owner. We've got situations where we might have 2 different pads on 2 different surface owners, and a facility on another surface owner. In some cases, we might have a lease road that crosses one surface owner to get to another. So that's not always the case where we're just dealing with one entity or one surface owner. We also deal a lot with ditch companies and other, as Don mentioned, some private utilities. And there can be other people that have an interest in the property other than the actual surface owner. So there's a lot of communication that goes on there in the planning phase. Next slide. Okay, next would be the construction phase. We typically start noticing, we have our notice requirements that we have that are required under the 300 series rules that we comply with, but really about 190 to 120 days out on our schedule before we start pad construction, we start engaging our surface owner. Sometimes we'll restake the pad location and pad corners, revisit, see if there have been any changes. We do walkthroughs of our road. We talk about our traffic and mitigation plan, make sure that's reviewed and implemented. We hold on-site meetings, which we invite the surface owners to attend those meetings, and they can ask direct questions with our subject matter expert and our departmental representatives. And really the pad construction is basically we're excavating the disturbed area and we're hauling material onto the location, and we're grading it and making it stable for drilling and completions operations. So there is some truck traffic associated with that. We often go above and beyond the rules. We'll contact building unit owners that are along haul routes that might see an increase in traffic. We make sure they have a company representative name and phone number. So if they have any questions or concerns, we prefer those to come directly to us so we can handle them in a timely manner. So there's a lot of communication that goes on the front end prior to pad build with the communities. Drilling and completions phase, that timeline really varies, and that varies based on, depending on the number of wells per pad. And again, operations are different. Every operator's development areas are unique. So there isn't really a consistent number of wells on pad, but that typically varies how long an operator is on a particular pad. But because the relationships have already been established prior to the construction phase, this really there's no surprise that there's a drilling rig or completions crew. The surface owner and the residents know that. And it's our goal to make sure they're not surprised by our operations. If we do have after hours concerns at night or on the weekends, where it may be more difficult to get a hold of a representative, we do set up a 24-hour hotline that's monitored, that we can address concerns and questions. And in regards to day and nighttime operations, in my experience dealing with surface owners and residents, it's often preferred because we finish the project in a more timely manner. So there might be differing of opinions, but in my experience, it's pretty consistent. They would rather us do 24/7 operations so we can get in and out of there in a more timely manner. Also, we do 24/7 operations to avoid any safety concerns in regards to startups and shutdowns. This gets more into the interim reclamation happens once the location has been drilled, completions operations, the wells have been turned online or put on production. That process is basically the reverse of the construction phase, and we're basically hauling the material off the pad, we're recontouring the area, and then we do leave some workspace around the wellhead, typically about 100 feet, could be more or less in some cases. That ensures that we have some maintenance and operations area for the future. We do a final walkthrough with the surface owner after the site's been interim reclaimed, and we make sure that everything's cleaned up, that everybody's on the same page, that we have our roads, access, any sort of damages are addressed at that point. And so we basically just kind of work to leave the land as the way it looked before, with the exception of the wells and the workspace around the wellhead. And then just to kind of emphasize the point, once the wells are on production, we communicate with our surface owners. There's required notice and subsequent operations and flow line abandonment, but there's a lot more communication that goes on just on a day-to-day basis through the life of the well, facility maintenance, road conditions, weeds, housekeeping. Sometimes fences need to be repaired, cattle guards need to be replaced. So we engage with our surface owners several times, if not more, throughout any given year. So there's a lot of communication that goes on there. Sorry, Don, can you go back one? Just wanted to quickly cover plug and abandonment. There's a lot of activity. I know with Chevron around the P&A phase of development, we're plugging and removing hundreds of wells each year. So there's a lot of activity here. The timeline on that takes about 4 days or so per well. We do send formal notice. The workover rig is required in that situation. We do discuss the flow line, the facility and the access route, confirm that, confirm private utilities, and then we also discuss the flow line intent with the landowner per the new flow line regulations that require operators to remove the flow lines. In some cases, surface owners would prefer that they be abandoned in place, and as long as there's no associated safety issues or there's no lines nearby, we'll execute a surface owner agreement with that landowner and send that into the COGCC for consideration of the variance. We do engage with building unit owners here. In some cases, if we have nearby, we'll let them know we've got a rig coming in. The P&A portion is usually daytime hours only, and at least in our situation with Chevron, I'm not sure about other operators. And oftentimes they don't do weekends. So usually the impacts to the actual workover rig and P&A process to the surrounding community is pretty minimal in most, I shouldn't say most, in some situations. And then basically what we're doing is we're removing the wellhead and associated equipment and removing the location and recontouring and reclaiming. That kind of goes into the plug and abandonment into the final reclamation phase. Next slide. Just real quick, I'm going to cover the surface use agreement more specifically. Operators have different approaches here, different forms, but the SUA really covers upstream development, covers the pad location, access, flow lines, and then it also covers any site specific or location specific issues that need to be outlined. And it basically is just to make sure that we've got our locations identified, that the surface owner knows that, and that we know where we can operate. And really it's to minimize conflicts. I think the surface use agreement benefits both parties and provides clarity in how we're going to conduct operations. So it benefits operators, but it also does benefit the surface owner. There is compensation. There's a term associated with it in some cases. And typically the surface owner concerns are addressed through mitigation. And sometimes we add that into the surface use agreement in addition to or maybe our Form 2A or our local government permit. And then our SUAs or a memorandum is typically recorded and filed of record. In our case, we submit the full document in its entirety, with the exception of the compensation that we have a side letter. So we submit that to the local government, in our case, Weld County and the COGCC. Midstream activities aren't typically covered under a surface use agreement. Those are compressor stations, gathering lines, trunk lines. Those are typically secured by a third party. So I know I may have gone over on my time a little bit, but that's all I've got, and I'd be happy to answer any questions you might have.
Thank you, Mr. Antonio, for the presentation. I had a comment, and it also maybe is a follow-up with a question. So, I mean, it seems to me that when the commission brought into its rules the alternative location analysis, it really sort of is adopting as a rule in certain instances what appears to be best practice by the three operators that have spoken in the room so far today. Would that be accurate?
Yeah, I would agree with that. There's obviously some components of the rules, the current rules as a result of the mission change rulemaking, and then in our case, some of Weld County's rules and regulations that have kind of changed the way we look at alternative location analysis. But I would agree with you that it's really, we're just formalizing it, that alternative location analysis, although we may not have used that term, has been done, at least in my experience. And I would say that started at the onset of horizontal development. When we were in vertical development, we had to be in those, the windows, those 400 by 400 foot windows. And then there was one in the center that our wells had to be in. So that really, because of the horizontal development, we're typically along or near section lines, and more optimal for the operators is to be outside of those windows. So really we've had to, to place a location, the surface use agreement and a location analysis has been somewhat of a standard practice.
Thank you for that. And I assume that since Mr. Joby and the other presenter, Mr. Bresnahan, have not interrupted, that they would agree with that answer as well. I mean, it seems like that is something that you guys are doing. Mr. Joby, did you?
Yeah, I would agree. I would agree with that, Jeff.
Okay. So let me ask kind of a follow-up question. If you flip back to, I think, slide 32, if you could, which was the slide that, yeah. So my notes here say that, well, there it says it in the second thing, engage with potential surface owner, take place 9 to 12 months prior to permit submittal. So I understand that is that was past practice. But Mr. Antonio or Mr. Joby or Mr. Bresnahan, how do you square up the idea that at the state you may be required to do an alternative location analysis after you do the permit submittal, which seems like this 9 to 12 months worth of work ahead of time is kind of like chicken before the egg, or whatever analysis you want to use. I mean, how does, so I guess maybe the question is, how do you anticipate working under the new rule that we've now codified, which talks about a more near in time alternative location analysis as part of the OGDP application? And I guess I would also speak to Weld County, who generally are requiring an alternative location analysis as part of their permitting process as well. How do those two permitting processes with the ALA requirements sink into the fact that you still are in this method of working things out 12 months ahead of time?
Yeah, that's a great question. I think it would be, it would probably differ amongst operators. But I would say when we have an area of development that the operator or that we want to develop, we know the COGCC, the rules and regulations. We also fully understand Weld County's rules and regulations. So we really take that into consideration when we're looking at locations on the front end, and really trying to do our best to, in all cases, comply with the rules when we actually site our location, so that we have a high degree of confidence when we go into a pre-application meeting with the county or with the COGCC that our location is going to be permittable, if that makes sense. So we really look at all of that. If we say we had a surface owner and there was a bald eagle's nest nearby, that wouldn't probably be something, at least with Chevron, that we would even want to consider in some cases. If we have kind of a red area or a zone that's restricted, we would focus more on other areas and see if we can figure it out that way. So I guess to answer your question, we understand both sets of rules, the local government and state. And as we do this in advance, we really try to bring a location that's going to the COGCC and the local government that's going to be successful. We don't want to go into a pre-application meeting with, hey, this is kind of what we're thinking, or, what do you think? I mean, we want to go in and say, here's the location we selected, here's our ALA, and here's why we think this location is most protective of public health, safety, welfare, and environment. That's kind of my 2 cents. I'm not sure if I answered your question.
No, that's helpful. I guess I was trying to peer around the edges about how you are planning on syncing up your best business practices with the rule now that it is more of a requirement. I mean, not in all instances, of course, but in those instances that are defined by rule where an ALA is necessitated, how this pre-work is going to sync up with that when you come in for the pre-app. And so that was a good answer. And I guess that was kind of the answer I was thinking I would hear, is that you are aware of the rules when you go into this pre-work analysis with surface owners.
Yeah, and I would,
go ahead.
I would just say, I mean, at least for Chevron, I mean, we're really, when we put an alternative location analysis together, whether it's required or not, we're proud of that. There's a lot of work that's gone into that. So the locations we pick, we're certainly proud of, and almost view it as an opportunity to showcase, the work we've done, the analysis, and how we've put this complex set of rules together, along with our surrounding residents and our surface owner, put a plan together that works for everybody.
One final question that is on a completely different topic, but I think I heard you say, you know, we work hard to get surface use agreements, but that perhaps certain communities incentivize getting the SUA, Weld County particularly?
I was just going to say the COGCC rules and the county 1041 WOGA process for our operations areas is, I would say there's a big incentive to have a surface use agreement. I see it under both sets of rules, a very difficult, not that it can't be done, but it may be more difficult to get a permit approved without one.
That sort of gets back to Mr. Duranlo's point that the bonding on approach to development is rarely used these days.
For Chevron, yes, it's rarely the case. In our case, and again, our acreage position is different. We're more rural. It poses its own challenges, certainly, but you know, we haven't had to bond in 10+ years.
Great, thank you. Commissioners, I apologize for dominating the early Q&A here, but I'm looking to fellow commissioners for questions. Commissioner Messner?
I can't be the only one that has questions. Anyway, thank you, Mr. Chair, and thank you, Mr. Antonio. That was a good description of that process, and that was helpful for me. And I've got just simple questions. Well, no questions are simple, but I'm really curious about that initial surface owner engagement and, you know, what that looks like. And are you just cold calling these guys, or, you know, sending letters, or, I mean, what does that look like? And what level of sophistication do these surface owners have in negotiations with a big company like Chevron to ensure that they're getting, you know, a fair deal, for lack of a better word?
Yeah, that's a great question. We know in our areas, it's more rural. So we have a lot of existing vertical wells. So we know our surface owners fairly well at the onset. I mean, we could pull up a map of our acreage position and we would probably know most of those owners and who they are, if they be somebody that would want to work with oil and gas companies or not. So we have a lot of just historical knowledge of our surface owners in our areas. I would say our surface owners are very sophisticated. They're familiar with oil and gas operations. Surface owners do share information and talk. So, you know, consistency for us is really important. And I would say the majority of the time, when it comes down to SUA negotiations, we have a standard form template that we use. But most of the time, we're working with their attorneys to formalize a surface use agreement. So that happens, you know, very regularly. So I think I answered most of your questions there, but we don't typically cold call surface owners. They kind of know who they are, or there's already an established relationship there because there's existing wells on their property oftentimes. So really more it's kind of leveraging and that's what my introduction is, how important that is, because we want to be able to call surface owners and say, you know, hey, we're Chevron and they want to work with us because we're fair in our business practices, that we're ethical in what we do. So that reputation and social license to operate is really important for that initial call.
Great, I appreciate that. I've got a couple questions around just how that development works with ag operations, so you've got a circle of corn or a circle of wheat, and it's a pivot irrigated, and you know you're coming in there and you're doing your development, within that circle, understanding that the final development is just outside the circle. How does that compensation work, or in those surface use agreements? Is that ag operator just not planting that season, or are they running their pivot 3/4? Or, how does that work on the ground?
Yeah, good question. So and it's different for every situation, but generally we try to plan our operations around, their operations. So if we can come in and do the drilling and completions and be done by the time, and do that in the winter time and be done by the time they start irrigating, that's ideal. However, due to the length of time for our operations to occur, that isn't always possible. So what we'll typically do if there is crop loss associated with that, that's a compensation as part of the surface use agreement. And we'll work with them to, sometimes they might have to stop their pivot and not irrigate a portion of their field. But we'll address that usually in the surface use agreement, and then we ensure that they're made whole on any kind of crop loss. I do think it's important to note that in some situations, it's not just a matter of crop loss reimbursement. Sometimes they have contracts and they have to provide a certain number of certain yield, to a producer. So even though our compensation, it may not matter to them because they need a contract to fulfill a third-party contract with a provider. So we work through those situations and do our best to minimize that. But that does happen from time to time. But typically, damages are negotiated as part of the SUA. And then when we're in the production phase and we have to get on there and do a work order or a recomplete or what have you, if there's damages beyond what the site that we're already using, then we will compensate for fair market value for any crop loss or damages.
Great, thank you.
Commissioner Gonzalez.
Thank you, Mr. Chair, and thanks to all the panelists so far for presenting. This has been good information. I want to peek a little bit deeper into the substance of the consultations. Right, we've heard a lot about, hey, we consult, they've got concerns, we talk to them here, we talk to them there. I want to understand how well a surface owner understands what's about to happen on their land, when it's going to happen, and how that line of communication is maintained. Essentially, I would think that the goal is to avoid surprises, and that everyone's on the same page from the SUA to turning dirt to reclamation.
Absolutely. I can take a shot at the question. So our consultations are very, I would say they're very formal. We'll send our letter. We'll have our phone calls. Oftentimes we'll have those conversations even before formal notice. And we go out there, we assign a landman or a land representative to the project. And really it's our goal that same individual sees the project from planning all the way through, even through final reclamation if we can do it. So the relationship we establish with the landowner is important. Oftentimes we'll have the surface owner, we'll meet on location. We'll stake out the pad corners of our proposed area so they can see what we're planning to do. And we'll bring in our construction department, sometimes our drilling and completions department, to talk to that landowner, answer questions. We might come in and say, hey, we want to come in off of a north-south county road, and they might say, actually, hey, can you come in, off of an east-west county road? So there might be some slight changes made at the initial consultation. So our goal really at the consultation is to make sure their concerns are addressed, and that we can, that the location's operationally feasible and safe for operations for us. So that could consist of several on-site meetings, or it could be one on-site meeting. Depending on the landowner, if they're more familiar, if there's not as many surface constraints, there might be, sometimes it can be a phone call, and we might be working more directly with a tenant farmer. And so it just kind of depends, but it's the communication and engagement with the surface owner. Like I mentioned, we provide them, obviously all the rules on notice we comply with, but we do additional notifications with the surface owner, basically anything short of pickup truck traffic. For a lease operator to go out and make, check the well or the facility, there's not typically notice associated with that, but almost everything else, there's at least a phone call, if not a formal notice when required, when we work with our surface owners. So there's a lot of communication that goes kind of through all phases of development.
And Commissioner Gonzalez, if I may jump in, and Mr. Antonio, I work with our surface owners directly in almost all instances, and it really is a matter, as Mr. Antonio says, a matter of building a relationship. I mean, we're going to be out here for such long. My surface owners have my cell phone number. It's not uncommon for if something weird is coming up, or even if they see someone on location that they're not familiar with, they'll give me a call, they'll give me a holler. And I really hope and provide them with the opportunity to do that at a win. So they feel like that, we're in it as partners. We're not in it as, we're going to come drill and be done. I don't want that. I want them, they'll give me a call if they see something out of the ordinary. Our lease operators gain a lot of relationship with the surface owners too, because we do operate in some of the rural areas a little bit too, and ag areas also. So it's more than just a surface man too, because your lease operators, they're out there on a daily basis, and ours get to know and understand the surface owners that we have locations on.
Yeah, and Mr. Gonzalez, I just echo Bob and Ryan there. I think they had some great points. They bring up some great points about just the touch points throughout the process that us operators are having with our surface owners. I think even during the grading plan process, when we get more formalized, even before that, we'll go out and do several on-sites with the surface owner and some of the construction team members to really highlight what will happen, what it will look like in a preliminary on-site meeting. And then once we really get some more maps established from our surveyor on how everything is going to look, temp tanks and so on, we'll even re-engage with the surface owner and let them know where things will be placed in the drilling process and things like that, so they can see. So there's no surprises. And so, sometimes things change, but it's just those touch points are very important. When things do change, we're on the phone with our surface owners or meeting out them on site and just letting everybody know, so we're all on the same page.
And just to also add too, on this example on the sheet here, we have those wells. You can see the pad is, it extends inside the pivot. And a lot of the reason we like to be outside of the pad, at least the wells, is if we needed to get a rig in or something, we don't have to enter into a irrigated pivot field. So in that case, on the bottom right, if we needed to get equipment on there for whatever reason, we can have kind of anytime access. So that's important to us. And sometimes we work with the surface owner to make pivot modifications to their pivot sprinkler to kind of, so we can again kind of coexist out there. So that also happens as well.
Thank all three of you for the answer to the questions here. Do we have any further questions for the panel? Okay, seeing none, we've been going at it for 2 hours and 15 minutes. I would suggest we take a 5-minute break. So let's return in 5 minutes, and then we will hear from the last panel for the morning, and then we'll take a 30-minute lunch break, and then we'll go into the afternoon session. So see you all in 5.
Thank you.
Okay, folks, let's start regathering here for our next panel. I see we have brought them to the fore, which was great work on behalf of our hearings folks.
Mr. Chair, yes, we do have everyone in the meeting that is going to be presenting for this panel.
Great. And hearings manager Larson, I didn't see that our one public commenter ever showed up, Ms. Nyholm. Am I correct on that?
That is correct, Mr. Chair. We have not been able to locate Ms. Nyholm.
Okay. All right, then. Well, then let's move on to our next panel. And this is a panel comprised of folks from Terra Energy, Caris, and Larimer Energy. Whoever wants to go first, unmute yourself.
Good morning, commissioners. My name is Brian Hotard. I'm the surface team lead for Terra Energy Partners out here in Parachute, Colorado. I've been a surface landman in Parachute for about 15 years, and we're still popping in the peons. I want to thank you, commissioners, for the opportunity to talk today about TEP Rocky Mountain. I find it a great honor to be able to speak with you guys and gals. Since I've been out here, it's been 15 years. When I first started, we had 26 rigs running. I've had the opportunity to work on all kinds of surface projects, from pads to roads, pipelines, compressor stations. I've attended all kinds of meetings, from energy advisory board meetings to community council meetings to one-on-one landowner meetings for all types of agreements. And I absolutely love the job from as much as I do today as I did from the first day. I love the open air environment out here in Parachute. And while I work in Parachute, I live in Grand Junction. I love the small town feel that Grand Junction gives us, in beautiful Western Colorado with the clean air and the big blue skies. A little bit about me real quick. When I moved to Grand Junction in 2006 from New Orleans, I met my beautiful wife, who's now a nurse at St. Mary's. We born and raised 3 kids in Grand Junction. I lovingly call them my hurricanes. If you ever met them, you would know why. I'm an adjunct professor for Colorado Mesa University in the Energy Management program. And I also am a rec soccer coach for 2 different soccer teams in Grand Junction. A little bit about TEP. Right now, we're the largest natural gas producer in the basin. We make a little bit over 700 million cubic feet of gas a day. That's produced from a little under 7,000 wells, a little over 1,200 pads. Right now, our bottom hole makeup is 54% fed and 46% fee. A quick rig update. We have 1 rig operating up in Rio Blanco County on a fed pad right now. And then when that rig is done there, it's going to come down into Garfield County and drill 3 pads back to back. And that'll take us out through the remainder of the year. Terra Energy, we strive to do the best we certainly can, want to be the best operator we can, and believe in doing things the right way. We're not perfect, but we certainly strive to be. I was invited today to discuss how TEP works with our landowners during the surface use agreement process, and that is fee and fed. My goal today is to kind of add some information to the already great presentations we've had this morning, and also present a snapshot of our daily work as it relates to collaborating with fee and fed surface owners, preparing lands for compliant and model drilling, and respecting ownership of the entire lands for all stakeholders. I've learned over the years to make it all work with our land department operates only one way, and that's open, honest, and transparent communication. Just like at home with your kids or your significant other, it's all about communication, communication, communication. Regarding fed lands, last year TEP drilled 4 of our 6 pads were on fed land. So I think for that reason, I offer a unique position from Terra to you that differs from how maybe things might be done on the east slope, just due to the magnitude of how much federal acreage we have out here. Before I explain the process on how we get a pad on federal land, first I'd like to discuss just the relationships that you have to have, and we've created with the White River Field office up in Meeker and the Colorado River Valley office in Silk, Colorado. I'm in constant contact with those guys and gals all the time. While they are a regulator in the federal government, they're also our surface owner, and we treat them as such. So how we begin as Terra Energy to get a pad on federal surface, it kind of starts, as you've seen some of the prior presentations, looking at the lease itself and trying to find where all the bottom holes you're wanting to acquire. Then as a company, we look and see where can we drill, where can we put a pad that can acquire all those drilling of those wells. And when we do that, we discuss internally any potential impacts that we see that may be an issue. At that point, if we feel as though we think we have a viable location, then we discuss our conceptual plan with the BLM. And at that point, once we have our conceptual conversation, then we have an informal field onsite, like an early consultation, if you will, to address any of the initial concerns that the BLM might have. And that's also kind of like what some of the previous operators have talked about. Is for us, that's where some of the access location assessment, ultimate location assessment, excuse me, is done as well. And we discuss everything about the site itself, and to see, you know, if does the BLM think that this pad could be moving forward or what have you. So at that point, if everybody seems to be somewhat agreeable to the location, TEP goes back internally and we create the pad design, the pipelines, the road, any ancillary facility that we need to produce and operate the wells. Once TEP gets all that created, all the survey drawings, and has a very clear and concise plan of development, that's when we have a formal on-site and visit with various BLM staff from various groups within inside the BLM, such as, you know, botanist, hydrologist, cultural ARC. At that meeting, there's also a COGCC rep, there's the county rep, and of course, representatives from the CPW. And sometimes we have some engineering contractors as well, such as geotechnical and visual resource management. The geotechnical side is, well, out here in Western Colorado, we don't have very much flat ground. So we want to make sure when we build pads, they stay there. And also on the visual resource management side, it's very important to the BLM on visual resource issues. And if you've ever driven down I-70, if you would be amazed to see how many pads you can't see, and that's due to the outstanding work of the visual resource management. So when we have that on-site with all the various groups, after that on-site, we always do a recap email and to get it to all the parties to make sure everybody's questions were addressed. And if there was any outstanding questions, we get those addressed as well. The BLM groups go back, and all the various groups that are on the on-site kind of go back and evaluate the site, and then provide guidance to TEP about any future resource surveys that potentially would be needed for our site. Once we get all the resource surveys sent to us that would be needed for the development of the site, we schedule those required surveys per the BLM or anybody, one of the other factors that would have been on the on-site, to identify any potential impacts that would be from our proposed pad and operations. Once we get all the surveys done and everything comes back, then we consult with the BLM and the other parties from the on-site to either avoid or reduce the impacts from the resource surveys, or we revise the pad, the pipeline, and the road to eliminate the impact. I think bottom line, to say it would be a collaborative effort would be an understatement. It's no detail goes overlooked. It's very thorough with all the multiple conversations, resource surveys, and the conversations that we have. I will tell you that every time we do a new project with the BLM, we always gain efficiencies. We learn things that we can do bigger, faster, stronger, and we incorporate those and memorialize those in our future projects with the BLM. Once we have resolved all the potential issues that maybe there were with some of the resource impacts, that's when we submit the application to permit to drill, the APD. And that's when the BLM starts their EA and the NEPA process from that point. You know, there are some actual instances out here where we actually drill fed minerals from feed land. And when we do that, it's very similar to the process I'm going to talk to you in just a few minutes about on fee service for surface use agreements. But we work with the surface use owner, the fee owner on a surface use agreement, and also consult with the BLM as well. Sometimes when we cross fee owners to get to the federal acreage, we also have to work with all kinds of different agreements to do that as well. And we work those in tandem with the actual process with the BLM. Bottom line is TEP communicates with all parties involved throughout the entire process. And I know that some of the prior presentations showed timelines, and it is very true. Sometimes it can be somewhat quickly, but then sometimes it can be several months up to a year or two. Just kind of depends on the size of the project and how large it is. On the fee side, so that's kind of how the federal side works for us. And on the fee side, TEP, Terra Energy, makes it a point to memorialize all of our access and usage with surface use agreements, whether it's split estate or not just for legal purposes, but it's also smart business and operational sense. As discussed earlier with some of the prior presentations, TEP does have a standard SUA form that we use, but they never end up the same. Everyone is negotiated differently, and all landowners have different ideas of how they want their property developed. The surface use agreement is a great tool for how the surface owner dictates how they want their property developed, and that's when all the say and everything is put into that one agreement. The surface use would encompass the pads themselves, the pipelines, the roads, any temporary right-of-ways needed, potential timing restrictions, interim and final reclamation, weed management, indemnification, you name it, it's all in that one agreement. It's very comprehensive. So when we start our SUA process, it's very similar to the Fed process, whereas internally we start off with looking at the bottom holes that we want to drill. Where can we find a pad that will allow TEP to drill all those locations? Then we do an internal evaluation of all the facilities needed, such as the road, the pipelines, the access roads, the pad itself. We look at who the surface owner is in the surrounding area, run title at the courthouse to make sure we know who we're talking to. And then we also identify any potential impacts. And this is where internally we would do the alternative location assessment to make sure, is the location that we're looking at the best one that we believe to fit everything. At that point internally, once we've done everything and we feel as though we have a very good viable plan of development, that's when we reach out to the landowner and discuss our conceptual plan. At that point, when we talk to them, if they say, hey, you know, Brian, I think we'd like to maybe push forward a little bit with this, that's when I tell them that we'd like to request an on-site with them, and I tell them all who's going to be there. And of course, when we show up, we have a representative from planning, drilling, completions, production, environmental. And I want to, as I mentioned earlier, a subject matter expert from all departments there. So when we're talking to the landowner, they have a very good understanding, and if they have questions, they can ask them the appropriate persons there. Plus for Terra, each one of those experts that are there, they all look at the pad through a different set of lenses. So at the end of the day, we really get a very precise and complex pad that everybody has had their input to put into it, because all the different groups look at it from different eyeglasses, if you will. Of course, on that on-site, we discuss with the surface owner or tenant or both, just depends on who's there. Timing restrictions, are there irrigation timelines, are there cow issues, cattle guards, gates, fences, hunting timelines, hunting access issues, all of it, everything's discussed. At the end of that meeting, then we go back and do a recap email, and that email addresses all the topics that were talked about on the on-site. And of course, if there was any questions that we're not able to answer on the on-site, we address them at that point. Once we've had quite a bit of conversation go back, if the landowner says, you know, I think this is something that we'd like to push forward with, then we get, excuse me one sec. Then we finalize the pad, the road, the pipelines, all the necessary facilities that we need on the property by one last on-site where everything is staked, and we want to make sure everybody is in agreement with what we've talked about through this entire time. At that point, if we do feel as though, and the landowner, everybody feels as though we've satisfied and we satisfied all the landowner's request and everything, that's when we start negotiating the SUA. And when you negotiate the SUA, like I mentioned earlier, TEP has a standard form, but no two SUAs ever end the same. Every surface owner has a different idea of how they want their property developed. And in such, that is all incorporated in it, whether we speak with the landowner or the landowner's attorney or whomever. So that process can take sometimes quite a while, just depends on the size of the project. Is it one pad? Is it multiple pads? Just kind of depends on the area. Of course, depending on where the pad is, we communicate with the adjacent landowners as well. So if we are on a very large piece of property and there's not any adjacent landowners near, well then of course there's not as much communication. But if we are, and we are somewhat rural out here, then we do communicate with anybody else that is needed to be communicated with. I will tell you that it's constant communication, as mentioned in some of the prior presentations, the timing of how all this works. Well, once we get the SUA negotiated and it's finalized and everything's done there, in a perfect world, you'd like to say that you would go ahead and start drilling the pad right away, but that's generally not generally not the case. It may be a year or 6 months or what have you once you get the permits, and then it falls in line on the drilling schedule. So Terra Energy, once we know that we get the permits and we are about ready to start construction of the pad, we have a pre-construction meeting, pre-construction on-site with the surface owner. And of course, the gentleman and our construction supervisor and all the parties involved to make sure everybody fully understands what's going to happen along the line. Once the pad is constructed, then before the rig shows up, we also do the same thing as with the landowners, let them know when the rig's going to be there and also offer them a rig tour if they would like as such. When the rig leaves, then the completions part starts. We do the same thing. We have a meeting prior, and if they would like a tour of the completion operations, absolutely, we'd love to show them that as well. Now on the interim reclamation side, once the completion operations are done and we get the pad and we start to, before we pull the pad back in for interim reclamation, we have another on-site with the surface owner. And this is where sometimes where the surface owner variance process comes into play. Because the surface owner, remember, when we did enter into a surface use agreement, we try to forecast everything that the surface owner wanted at that time. But by the time we get to interim reclamation, it may be 3, 4, 5, 6 years later down the line. The surface owner may have changed their mind, or maybe the property has been sold and another person has a completely different outlook on how they want their property reclaimed. So that is something I know that we're going to be talking about. Some of the other presenters are going to be talking about a little bit more in depth in a few, but I just wanted the commissioners to see on the surface, on the reclamation side, why there are some issues when it comes to interim reclamation. I will tell you, our landowners are our partners, they're our friends, and it's only through constant communication of open, honest, and transparent communication will the whole process work. We are, as mentioned earlier by one of the gentlemen about, having cell phones. Everybody has my cell phone number out here. They can call it 24/7, 365. I have a 3-year-old son, as I mentioned earlier, that keeps me up all the time. So we're always willing to answer any question at any time. During the SUA process, like we just spoke about, being fee or fed, sometimes you will need various agreements from the adjacent surface owners. And we work those in tandem as well. And with those adjacent owners, we also communicate with them about the oncoming construction, the drilling, completions, and interim reclamation as well. Indeed, the SUA is an important requirement for permitting and definitely serves that regulatory purpose. But TEP believes it to be foundationally a relationship document that covers all facets of the land use for operations, as well as all the parameters for all the aspects of the pad's life, whether it be construction, interim reclamation, or final reclamation. Throughout the entire SUA process, all the parties internally are kept apprised of this, what's going on with the pad. So everybody internally knows the workflow and any timelines or expectations that are needed from TEP or the landowners. We make sure everybody knows that the entire way. That gives Terra and all affected owners, which would be actual and adjacent, the peace of mind of predictable and efficient operations. This is because reasonable accommodation, which was talked about earlier on the accommodation doctrine, reasonable accommodation is not just a legal concept to us, it's just the way we believe in doing things. Therefore, when we work with the BLM or the good people of Garfield County or Rio Blanco County, we are working to secure everyone's best interest at all times. I know that because the last 15 years since I've been in this position, the only way to operate with our surface owners, whether fee or fed, actual or adjacent, is through open, honest, and transparent communication. I do appreciate, thank you, commissioners, for taking the time for listening to me today and talking about the surface use agreement process being fed for Terra. Mr. Jeff Kirtland, our regulatory manager, is on the call now, and we are happy to answer any questions that we can. I know that Karis is up next, and we're always available to have any discussions with you or what have you. But thank you very much. I greatly appreciate it.
Thank you, Mr. Hodard, for that presentation. Good to see you there, Mr. Kirtland. Do commissioners have questions for the panel? Commissioner McGowan?
Thank you, Mr. Chair. So thanks for your talk.
Yes, ma'am.
I was wondering if you could explain to me, sometimes development of federal minerals happens from fee lands.
Mm-hmm.
I'm not sure I understand what that means. Does that mean federal minerals are sometimes under a private property owner's land? I'm not sure I understood what that meant. Sorry.
No, absolutely. That comes into the split estate. You know, in the United States, there are two different estates. You have the surface and the minerals. And sometimes when you have public domain lands and acquired lands, but I guess the best way to say it is sometimes that the surface and the minerals are separately owned. And out here in Western Colorado, there's a few instances where we have a pad on fee property that maybe will either be overlying federal minerals, or we're drilling into an adjacent lease just off to the edge of the fee property. So when we do that, we need to work a surface use agreement with the surface owner and all the impacted parties. Plus, we consult with the BLM as well. It's a great question. Thank you.
Thank you. And then, and maybe we're going to get to this. So if I'm jumping ahead, just tell me to wait. What happens when you have a surface use agreement with a property owner and that property owner sells their property and a new owner moves in? Do you have to start over again, or does that agreement, what happens in that instance?
Outstanding question. Thank you, Commissioner. Well, the agreements run with the lands. They don't run with the surface owner. So when a person buys another piece of property, or say buy a piece of property, when they go through the whole purchasing process, the surface use agreement would be a part of when they purchase the property, and they would know that. And then of course they would contact us. And that's a great point about that, Commissioner, because that's also when that new surface owner may have a completely different outlook on how they want their pad reclaimed than the prior surface owner. So that's when that surface owner variance plays a huge part for us out here in Western Colorado, because things change, surface ownership changes. But outstanding question, but to answer it is the agreement runs with the lands and not the surface owner. Thank you.
Thank you.
Mm-hmm.
Commissioner Messner, then Commissioner Gonzalez.
Thank you, Mr. Chair, and thank you, Mr. Hodder. That was a good talk. I did have a few questions. So I think the first question is, how does siting decisions and surface use agreements and the different negotiations get affected by different federal resource management plans and those type of processes?
On federal lands, sir?
On federal lands, yeah.
Well, when on federal lands, when we have the first, we discuss the conceptual plan with the BLM, sir. We go through and we initially talk about the pad itself, and then when we do that informal, that early consultation, if you will, then we talk about all those different aspects, all the different impacts that could potentially be there. Some we may know of existing, some we may not. That's why after the formal onsite, when one of the various BLM staff come on the onsite, you know, they're the hydrologist, the botanist, and everybody, they look through it at a different lens. And then they come back and say, okay, you need this resource survey, you need this, you need this. And when we get that information back, then that talks about all the potential impacts that may or may not be there.
I guess my question is, does the resource management plan for the particular agency direct where you can cite these things?
Let me add to that and maybe respond to that question more directly, Commissioner Messner. Yes, the simple answer is yes. I mean, there's two things that sort of direct the federal government with respect to the siting of multiple uses on the public land. So the resource management plan certainly is a function of that. In addition to that, the lease itself will come with stipulations and limitations that are part of that analysis overall, and that's really a first step of how that analysis occurs. And that resource management plan is just a basis of what leads into what will then be a more sort of direct analysis of the project itself. And that's when, once we've established that relationship and that conversation with the federal government and then applied for those permits, that's when that very specific analysis through NEPA occurs. And the considerations that are outlined in the resource management plan are more applied through the stipulations and what's appropriate through that greater and more specific analysis, if that answers your question.
No, that does. That was really helpful. Thank you. And then and kind of following up with that, understanding that some of these leases on federal lands, get acquired, but actual activity may or may not happen on those for some significant period of time. When do you engage in more of those specific surface use agreements or stipulations, on federal land, federal minerals, after that lease has been acquired?
Well, I think when we acquire a lease, federal lease is good for 10 years. And it kind of depends on where it falls within our development plan and where we are on our drilling schedule. So once we get a lease, then we have a significant amount of time, like you mentioned, Commissioner, to develop it. And it kind of just depends. So when we finally start getting to that area and start the plan, we have an annual meeting with the BLM. As a matter of fact, we just had it 2 days ago, or yesterday, excuse me. And we discussed that. We talk about what we did in 2020 and then what we're going to do in 2021 and on. And then that's kind of it forecasts the BLM of what's coming down the pipe so they can get prepared for it. And in those meetings, we have discussed our future plans. Now, sometimes those plans are just what they are, a draft in its true nature. And so that's how the federal government, the BLM out here, whether the White River office or the Colorado River Valley officer, knows what's coming down the pipe is these annual meetings that we have. Which in those annual meetings then spur quite a few other informal early consultations and such once we start each pad, sir.
Sure. Thank you. That makes sense. And remind me, because I think I'm confusing myself, but if you've got private surface and you're accessing federal minerals, that still requires a federal mineral lease. Is that correct?
Are you saying, so if you're accessing federal minerals from a fee property?
Correct.
You still have to have the federal lease, yes, sir.
Right.
Now it's just simply is where's the surface equipment going to be?
Right.
And if it is from a fee surface, sir, which it does happen out here sometimes because, Western Colorado, there's not a lot of flat ground, sir. So that we drill from here on a fee land and the wells go into the federal lease. So that's how that would work, sir.
And if it is on the private surface accessing federal minerals, does it still go through the full federal NEPA, EA, that whole process? I mean, I guess I'm kind of curious advantages, disadvantages of siting on, fee land or private land versus federal land to access federal minerals.
Well, I can answer the first part of it. I think Mr. Kirtland can answer the back end part of it. But as far as what happens with us is you still do a surface use agreement to make that happen. And the BLM consults with you. But as far as everything else, Mr. Kirtland can answer that part.
Yeah, effectively, when we are targeting bottom holes that are in federal minerals, we are required to submit for an APD. So therefore, and in that's called connected action. Well, there's different types of connected action, but effectively, since we're targeting and applying for those minerals, those bottom holes in federal minerals, we do have to apply through that APD, and that would have to go through the full analysis and consultation with the BLM.
Mm-hmm.
And just to clarify, one thing I said earlier about leases, there are stipulations that are attached to leases that are based on that resource management plan, and basically essentially the federal oil and gas leasing EIS. So again, there's multiple layers that the federal government has applied a level of analysis for all of these leases, and there will be different stipulations for different leases depending on sort of when they were issued, where they're located, et cetera. But yes, we do have to engage with the BLM through that permitting and effectively that NEPA process. And just as a sort of add on to that's another area where we have to work with the surface owner to ensure that they have an understanding of what the federal government requires. So in other words, you might have a surface owner that effectively will have to provide access to the federal government on their property to allow for resource surveys and other type of analysis. So that's a very balanced relationship that we have to work through with regard to that ongoing communication.
Yeah. And Commissioner Mesner too, sir, is when we have that annual meeting and we talk about, hey, this is where we're thinking about being in 2021 or 2022, the BLM's various staff members go back, or the National Resource Specialist, they go back and look at the leases, so that when we do start to talk about those, they say, hey, you know, guys, there's different stipulations in each lease, so that when we have that on site, that's in everybody's mind, and we work through it at that point, sir.
Great, thank you. Just maybe a couple more questions here. So understanding in these interactions with, you know, all the different entities that you're talking about, the communication and the back and forth, where does, you know, I know that you guys mostly work in Rio Blanco and Garfield County.
Mm-hmm.
I think that most of Garfield County is a use by right. Rio Blanco doesn't have oil and gas regulations. I mean, so how does that interaction work with the counties, or is that not happen because they're choosing not to regulate?
I'll answer that, Commissioner Mesner. Well, and just to sort of, I guess, correct you to some degree, Rio Blanco does have, Rio Blanco County does have an oil and gas regulation. They do require a special use permit for oil and gas. So
Good.
when we are interacting with federal land, they are one of the counties that actually require permitting on federal land. So they cover the scope of their lands. With Garfield County, you are correct. Their current land use code allows for use by right in certain areas that are zoned. For instance, public lands are a use by right. And I won't, you know, speak for Garfield County, but I can tell you that conversations we're having, they're currently looking at revising their land use code to allow for some level of permitting. I think they're working through that process currently, and so I expect that will be something that is much more included in that process. However, when we are permitting and working with these agencies, particularly the on-sites with the BLM, for instance, that does include representation from the county. So we do extend invitations, and that's typically done through the BLM. However, in our planning process, we have a good, you know, relationship with the LGDs, local government designees from both Garfield and Rio Blanco County, and we keep them pretty much apprised of our plans on an ongoing basis. So, but to your point, yeah, I think you're going to see more from Garfield County probably in the future.
I appreciate that. And I apologize to Rio Blanco County for not knowing that they did have a special use regulation. Are they involved in the siting then as part of that, that special use permit that you received from them?
Yeah, to some degree they are. I mean, effectively their regulations sort of give a level of impact, and they allow for a certain type of activity, and then up into larger, more impact activities that require planning, commission, and board approval, effectively. So they are involved in that process.
Great, thank you.
Commissioner Gonzalez.
Thank you, Mr. Chair. And thank you very much, Mr. Hotar, for your presentation. Very informative. Really appreciated that. I've got a couple questions unrelated, so I'll start kind of following up on Commissioner Mesner's line of questions about the interaction of BLM and fee land. And so I'm curious, what kind of input does the fee landowner have in a BLM on-site consultation in the siting around a BLM APD?
The pad is on federal surface, sir?
No, fee surface, federal minerals.
Fee surface.
Yeah, so the fee owner,
Okay.
right? The rancher, the landowner, they're subject to all the stipulations of the BLM.
Right.
What kind of input do they have, and how is that coordinated, and are there any conflicts, and how are those resolved?
Well, absolutely. Great question, Commissioner. Well, when we do the on-site, the landowner truly dictates how they want their property developed. But then the BLM has, they consult with us and they have some input. But at the end of the day, it is truly the surface owner. Now, as Mr. Kirtland said earlier, there are sometimes we have to do some resource surveys and things of that nature that will have timing when we're allowed to be or not be there. But as at the end of the day, the surface use agreement is with the surface owner and not the BLM. And how they want it all done, that's all negotiated with that fee owner. And the federal, as far as the BLM, they just have some input on the side. But at the end of the day, it's the surface owner that gets to dictate how they want their property developed.
Very helpful. Thank you.
Thank you, sir.
My next question is about, we talked about kind of the SUAs and a subsequent transfer of ownership of the surface, right? You know, so the SUA is signed by party X, party Y buys it at some point, you know, during the term of that SUA. And you talked about it running with the land. You also mentioned that the buying party, you know, usually knows about that. Mm-hmm. How do they know about that? Is it something you reach out? Is it because it's of record and they're getting it in their title review? How does that work?
Great question, sir. That would be in their title review, I would assume. I believe that'll be like when they do a title search on the property and the title commitment when you purchase the property, that would be involved in there. And as mentioned earlier in one of the prior presentations, the reason being it would be, we don't record our surface use agreements, but it would be the memorandum that would have been recorded. And then that would show up. And then if the surface owner, which it happens quite often when if they're looking at potentially buying a property, they give me a call and we talk about it. And sometimes if they want to meet out there or what have you, is there any future development? And all those questions are answered. And we go through that whole process with any new owner. Now, granted, I don't run title every day to see who buys new property, but if the surface owner does have a question when they acquire it or before they acquire it, Kirby Wynn, they usually call Kirby Wynn, who's the Garfield County Oil and Gas Liaison, and then he usually gives them straight to me, and then we take care of any issues they have, sir.
Thank you.
Thank you, sir.
Other questions from the commissioners to the panel? Great. I see Karis has showed up. I believe they're next. So we look forward to hearing from them. Thank you very much.
Thank you, Commissioner.
Thank you very much, Commissioner.
Hi there. I think we're ready to go. My name is Mike Leibowitz. I'm the lead geologist for Karis Oil and Gas. We're going to talk to you today about our site selection process and surface owner rights. If we can go to the next slide. So for Karis Oil and Gas, site selection is a combination of subsurface and surface parameters. So it starts with the subsurface and the architecture of the reservoir. So I know a few of you have sat through this before, and I apologize for any redundancies. But the Williams Fork, pardon me, the Williams Fork is quite a bit different than what operators on the Front Range are drilling. We're drilling a highly discontinuous reservoir that's 3,000 to 4,000 feet thick. Because of the orientation of these reservoirs, we utilize vertical well bores throughout the pay section. Rather than drilling horizontally, we have to drill directionally out from a central location, which is quite different. We start drilling directionally almost immediately out from the surface conductor 90 feet below surface. And that puts a pretty significant limit on how far laterally we can reach, so to speak. And most of the time, that's around 3,000 feet from the central location, plus or minus. In addition to that, we have to work within all the surface parameters that are given. So there's quite a bit of natural topography that has to be handled in the Piceance Basin. We try to drill as many wells from one central location to reduce impact. We have a lot of wildlife resources to protect and consider when we look at our surface locations. Safety is paramount, both of during drilling as well as production operations throughout the life of the pad. Infrastructure has to be considered, and we'll get to that in just a moment, why that plays into the location. And then mineral resources have to be respected. And of course, the landowner has to agree to the surface disturbance that we require. If we can go to the next slide. So I know a lot of you have seen this again, but just to reiterate, the DJ Basin is there on the right. So they're targeting these highly continuous limestones in the subsurface, and they drill approximately a mile before they kick off laterally. So they have a lot of weight on bit at that point. They can drill laterally for several miles with that orientation. Where we're drilling, which is the schematic on the right, on the left, we have a reservoir that's about 3,000 to 4,000 feet thick, depending on exactly where we're drilling. We start drilling laterally right out of surface. Again, that restricts our weight on bit. So we have a little more of a limitation on how far we can physically reach. In addition to that, you can see that just the shape of the reservoir is completely different, right? We're targeting these highly discontinuous sandstone bodies that are gas charged. On the Front Range here, they're targeting these very laterally continuous oil charged limestones. So all this has to be taken into account when we work with our reservoir engineering counterparts and our drilling counterparts to come up with a development plan for the physical well bores, and that all plays back to the surface location. If we go to the next slide. In addition to the subsurface issues, we have some pretty significant surface issues that have to be taken into account. So this is from one of our core development areas in the Piceance Basin. This is about 20 miles north of the town of Parachute. This is from Google Earth, and you can see the topography cross-section represented at the bottom of the photo here. It's the yellow line running across the map. There's approximately 500 feet of topography valley to valley, or valley to ridge across here. And you can see there are 6 or 7 valley ridge kind of pairs just in this short cross section that we're showing. So we refer to this as corrugated tin because that's kind of what it resembles. And this is where we are developing right now. So in order to do this right, we have to take a lot of environmental considerations into consideration. We can't be drilling in a wash or a stream. We need to have access via roads. And then we have to ensure that we have takeaway access via pipeline. In this particular area, for instance, we've centralized all of our gathering facilities. So we have no trucking and we have no tank batteries on location. But that means that we have to be able to run a pipeline on a sufficiently low gradient to be able to transport all those fluids back to a central processing facility. If we go to the next slide. So this is a topo map across the same area. These are 40-foot contours. Again, you can see there's several hundred feet valley to ridge. And so once we work with all the stakeholders, including the BLM and surface owners out here, and look at all the environmental restrictions and safety issues we have to deal with, it's really restricted development to the tops of these ridge lines. And so if you hit forward, we'll get where the pipelines and roads are here. Yeah, and let's go ahead and hit forward one more time. Thank you, Holly. And so you can see we find a location that's, again, sufficiently low gradient or flat enough to house a drilling pad. And then we have to be able to plot a road out there. And in addition to that road, we're going to need a pipeline. And the pipeline can't be going up and down constantly, or we're going to end up with sumps in the pipeline. Those lead to safety and other issues later. And then in addition to that, we have to work with our 3,000-foot radius from the surface location. So all of that goes into account when we come up with our development plans. And this is just kind of an example of what this one development plan looks like. None of this is yet accounted for the surface owner issues, and I'm going to let my colleague Zane cover that in the next slide. If you'd like to take over, Zane.
Thank you, Mike, and thank you, commissioners, for allowing us to present today. I'm Zane Lay, as Mike said, surface land manager for CARIS. And so as Mike spoke to, our development, not unlike Tara's or Laramie, who will speak after us, is generally off of multiple well pads. And we are targeting as Karis to drill somewhere around 30 wells per pad. A lot of that is driven by our reach and the topography and the pad that we can fit and where we can fit that pad and the number of bottom holes that we're able to reach. But that is what typically we would be looking to reach from a single pad. That type of development allows us to very much consolidate disturbance and reduce the overall disturbance. We would typically be drilling from a well pad that has an initial disturbance area of around 10 acres and then is reduced through interim reclamation to somewhere between 2 and 3 acres for the life of the wells. This would be as opposed to vertical well drilling from single well pads where we would see a 2 to 3 acre pads, and that would be 34 individual pads with associated roads and pipelines. And so we would see a disturbance area to develop the same amount of reservoir of close to 80 acres as opposed to maybe an initial disturbance of 12, 14 acres when we take into account road, pipeline, and pad, which would be reclaimed back to that 2.5 to 3 acres with a little bit of additional disturbance for the access road. So much more efficient and prudent use of the surface. And then this also, in addition to the reduction in the surface disturbance, also allows us to more efficiently operate and significantly reduce truck traffic and the overall environmental impact by just consolidating all of that to a single point and being able to access one single point instead of having to run traffic to multiple well sites. So that's a little bit on the multiple well pad scenario. And Holly, if you could skip to the next slide. This is a little bit just an overview of our site selection process, much as all the other operators have spoken to. We have a lot of upfront in-office work to identify locations based on the geology, the topography. We have wildlife layers that we map against, the 410 waterway mapping. All of those factors are taken into consideration before we ever really propose a location and begin looking more specifically on the ground at a location. So we would begin that initial process. We would then, as we have identified some preliminary locations that we think may be workable, we would at that point begin to engage with the surface owner. And I think, as all the other operators have pointed out, that's by and large, we have existing relationships with a large portion of the landowners. They know us, we know them. We've worked with them before. And so that would be a process to then go to them and ask permission to begin doing the on-the-ground survey and begin looking at that. Following that, we would then, once we've compiled the information we need to refine that decision, we would conduct an on-site. And this isn't to say that we wouldn't meet on-site prior or at any other points, but just as an overview, we would then do the more formal on-site at this point with both the fee service owner, the agencies, the county, and in many cases, as Brian pointed out, we do have federal mineral estate underlying fee surface, and so we would have BLM involvement as well on those on-sites. And then from those on-sites and the discussions on those on-sites has been pointed out before, then we would further refine that and adjust those site parameters to make sure that we fit within the surface owner's land use, within any constraints for wildlife, waterways, any of those concerns are taking into account, and we account for that in the final site design. And then we would begin the process of negotiating the surface use agreement. Following that, we would then begin the formal permitting process with BLM, or in the case where there isn't BLM involvement, would be solely with COGCC. And then once those permits are approved, then that fits into our rig line, and we begin the process of planning construction. When that pad comes up on the schedule, we would provide notification to the owners. Again, as I think most of the operators have pointed out, that isn't a hard stop on communication. And then when the requirement says we have to provide notice, then we've talked with them again. It's very open communication, continual communication, and keeping them apprised of what's coming ahead. And then we'd of course begin construction, mobilize the rig to location on a pad, multiple well pad like this, 30 plus wells. We would anticipate occupying that pad for a year to year and a half. We are doing simultaneous operations, so we are drilling and completing wells on the same pad at the same time. So we will drill a pod of wells, usually a group of 4 to 8 wells, then slide the rig off of those wells, move to the next pod, and as we continue drilling, we would be completing the wells that we had previously drilled to help tighten that time frame and lessen that impact again, to just make that more concise and get in and get out and return that land back to its previous land use, which would be the interim reclamation process. You then have the production life of the well. Again, continued communication with the landowner for activities and any questions, things that may come up, oddball activities. I think a lot of the operators have pointed to that in that continual communication process. One of the points that I don't know if it has been talked about, but we see great benefit and our landowners see great benefit where our lease operators do develop a working relationship with the landowners we operate on, and they're able to be an extra set of eyes for these landowners where we experience some trespass issues during hunting season or other times of the year, or a lease operator might see something odd going on a property, contact me or my team, and we reach out to the landowner and say, hey, did you know that this was going on your property? This is odd, not something we normally see. Just wanted to be a good neighbor and point that out to you and make sure that that's something that you're aware of and you have approved. So then we go through the production life of the well and come to the end of the economic life of the well, and would plug and abandon the well. And this is a process that, as others have spoken to, again, very heavily vested with the landowner communication and conversations to determine how the landowner needs to have the well pad reclaimed, and also any improvements that the landowner would need to see left behind. In many cases, we have access roads, the pad surface itself, sometimes electrical run to the pad, and other improvements that are of huge benefit to the surface owner, and so they asked that those be left. And so we walk through that process and then conduct that final reclamation. Go ahead, Holly. And so just a little more in depth on the surface owner, that initial engagement process. Again, as we begin to determine feasible locations or what we see as being feasible locations, we would be in contact with that landowner to obtain permission for civil surveys and any environmental surveys that we need to conduct, working with them to determine if that location is indeed workable for their land use plans. And then we would be going forward with drafting of well plats and then reviewing that internally, making any adjustments necessary to accommodate the landowner's needs, any wildlife mitigations that needed to happen that we didn't see in our initial investigation. We'd be conducting the on-site and then moving forward with negotiating that surface use agreement, and then upon execution, beginning to submit the permits. That time frame varies, as I think everyone has pointed out, due largely to the scale of the operation that we're looking at, if it's a single well versus a multi-pad development on that owner, and also the familiarity of the owner with our operations, with us, and you know, their feelings and different constraints that they may need to have put in place for our operations. Go ahead, Holly. So as has been spoken about a little bit, not only does our topography vary quite a bit from some of the front range development, we also, our land use is somewhat different. In most of the counties, the predominant land use is rangeland rather than irrigated cropland or more developed urban areas. So our operations are primarily on rangeland. And so that some of that drives that surface use agreement, and some of that relationship and how we interact with the surface owners is driven by, you know, the type of land that we're operating on. And as has been stated again and again, our objective is to maintain a positive relationship with the surface owners. Beyond the initial permitting, this is a long-term operation. We're here, they're here, we want to work as neighbors, and we need to keep that relationship throughout the life of the well and be able to be open and transparent in our communication and active in communicating what we have going on to maintain that relationship and that license to operate that I think has been referred to. One note here, as I think Brian pointed out, the BLM is the largest surface owner on our leasehold, and so we operate under the resource management plans and then are walking through the NEPA process for permitting of our wells. Go ahead, Holly. Not unlike the other operators that have spoken, we have a strong commitment to our community and to the agricultural community. We know how important that partnership is with our landowners and with the agricultural community. We do a lot of work with the local 4-H's and in the auctions, purchasing animals and to help you know, perpetuate the ag community and grow new leaders in that community. And we really value those partnerships. We know that these guys often on rangeland are operating on very, very tight margins. And so in many cases, our operations can be of huge benefit financially to them through that surface use agreement and damages and other compensation from our activities. And in addition to our involvement on others' lands and the reclamation of those lands to return that to use, we also own our own surface, a large portion of surface that we manage for wildlife and rangeland. And we strive to be prudent managers of that and improve wildlife habitat and livestock grazing on our own lands. We work under a wildlife mitigation plan with in partnership with CPW, and really strive to not only in our operations but outside of our operations improve wildlife habitat, improve forage value and for livestock, and really be a prudent user of the lands, not only on other landowners but on our own as well. Go ahead, Holly. And as I spoke to a little bit, in many cases, these surface use agreements and right-of-ways and the considerations that are paid out of those are a huge benefit to surface owners that are really operating on tight margins in livestock, in agricultural operations. And so this can be a great benefit to them to be able to derive income from their land that would otherwise not provide near the level of income. So, you're looking at lands that maybe you could graze cow-calf pair on about 80 acres of land. And so our development and the ability to pay damages and consideration is a significant boost to their economics. And then also, as we've spoken to a little bit previously, in many cases, our infrastructure, roads we construct, fencing, the road improvements that we do to facilitate our operations are a huge benefit to the landowners in their use of their property. Go ahead, Holly. A little bit on interim reclamation. As most of you know, on cropland, that is to happen within 3 months of the completion of drilling and completions operations. On non-cropland, 6 months. And our goal in this is to really to honor the surface owner's needs. And we want to get that done as quickly as possible, but do it on a time frame that works best for the landowner and works best for the land. I think, as Brian pointed out a little bit, we often have landowners that use their lands or lease their lands for hunting and derive income from that. And so oftentimes we're working around hunting season and their use of the land for hunting with both our drilling and completions operations, construction, and then also reclamation to make sure that they're able to optimize their land use and that we're not disrupting that. We do have situations where we are looking at variances. Many of those happen around wildlife timing limitations on placed upon us by BLM, Fish and Wildlife, or CPW, where we complete drilling and completion, and then we don't have time before a timing limitation sets in to finish interim reclamation, so we need to delay that to the following season. We also want to seed and reclaim during optimal conditions, generally late fall, so that we have the best chance of that reclamation being successful and being able to return that to ag production and wildlife usage as quickly as possible. So we want to do that at the right time. We do have variances when we, in an attempt to minimize our disturbance, will utilize a previously drilled pad to remote frack or move water through and handle water on, so that we can complete an adjacent location and not create a whole new disturbance to facilitate those the facilities needed for those operations. And then we also, from a surface owner standpoint, have some cases where we would see a variance request where their needs would trigger us to not be able to comply with the COGCC regulations on interim reclamation because of timing that they need or use that they want for the area that we have occupied during drilling and completion. Go ahead, Holly. And I think this has been pointed out a number of times. Final reclamation and the abandonment process is it can be a difficult process, and we are often caught in between trying to comply with the COGCC regulations and what a surface owner desires for his property, his or her property. Sometimes there's conflict there. They have asked for a road to be retained. They want the working surface of the pad retained. In some cases, they would like us to extend that and open that back up to or beyond what the original drilling and completions footprint was, because they want that whole area. As has been pointed out, flat surfaces in this country are a rarity and a precious commodity. And so there's many occasions when our landowners want that left or even expanded so that it fits with their land use. And that often places us in conflict with the rules. And then just a note here that, you know, what we desire is to have clear guidance from the COGCC as it concerns the variance process. I think Chevron pointed out and others, we have a large number of variances that are sitting, still waiting direct review. And we have landowners that they want their lands returned to them, and it's still on hold because we're waiting those approvals. And so we're asking for this commission just to give us clear guidance so that we can walk more quickly and efficiently through that process and get these lands returned back to the landowner and to their land use. Go ahead, Ollie. So I think that's all. If anyone has any questions for us, be happy to take those now.
Great, thank you. And if you want to stop sharing your screen, we'll be able to see each other a little bit better. There we go, great. Thanks for the overview. I guess I would follow up with a question before we move to our next panel. To the CARES team, Zane, is that right? Yeah.
That's correct.
You expressed, you know, kind of the way that you've done business, or the way that you're doing business, which involves, you know, this 8 to 12 months worth of work. And I know a lot of your work is on federal land, and I know CARES is also a large surface owner. But how does that, and this is a similar question I asked to the DJ Basin operators, you know, we do now have in place situations in which the commission will require an alternate location analysis and may not approve the location that you spent this 8 to 12 months work on before you come to the commission and ask for a permit. And I'm trying to balance out how you're planning on operating under the rules that are in place now, which in my opinion requires, I mean, I guess you can roll the dice, but it seems like to me that there ought to be some more upfront work with the permitting process as you're doing the work with your fee surface owners. So any thoughts about that would be helpful.
Yeah, I appreciate that question. It is, I think this is as I think everyone has pointed out, processes that we already had in place, that we were doing alternative site analysis and trying to optimize and best use the land and cite our locations to be, diligent and prudent in the use of the land long before Senate Bill 181 came into play. I think the new process is more formal, and it does, we are going to be caused to formalize some of that and more and share all that background work with through the permitting process to justify our site selection. And yes, you are correct. One of the agencies that is involved in that upfront on-site would be our representative from the Oil and Gas Commission to, even up front, very early in the process, engage on where we're at, how we've come to the selection of that location, and then understand any issues that would be seen from the Oil and Gas Commission's standpoint with that selection of that, and that happening very early on in that process through the on-site, and then continued communication following the on-site.
And if I may, I would just like to echo Mr. Antonio's remarks. We're not going to bring a location to the COGCC to permit that we know is going to fail, right? We're doing all of this background, all of this desktop review. We'll probably have a lot of upfront communication with COGCC now, more so than we did. But this is we're bringing you locations that we know will be successful.
Well, I asked the questions because I want us to have a successful permitting regime, that is reflective of 181 and it's protective, but that we're moving forward, successfully with good locations. So that's why I sort of asked the question I appreciate that answer. I had heard the answer from some of the DJ operators, and, obviously this will play out as you work through permits, and, I pledge our staff is available for that as well. So thank you for that. And if any of the other operators desire to, further answer that question, it can consider it to be still out there. Other commissioners with questions? Commissioner Gonzalez.
Thank you, Mr. Chair. And kind of following up on that question, because I was thinking about that from the last group as well, is, how long in that 8 to 12 month planning process, are you actually negotiating with the surface owner?
So from our standpoint, I would anticipate that there's a huge range, and I think as Mr. Hotard pointed out, depends a lot on the scale of the operation we're looking at, whether it's a single well. Also depends a lot on the surface owner and how familiar they are with us and our operations. But in general, I would say anywhere from 2 months to a year or better that we would be actually actively negotiating an agreement. Again, very, very highly dependent on the landowner, on the situation, but that would be an approximate time range. I think one point that was asked earlier is, the sophistication of our landowners and things, and much like was stated previously, while there is a pretty significant range, most of our landowners are fairly knowledgeable of oil and gas operations and fairly sophisticated in understanding of those agreements. And from my standpoint, I always encourage a landowner that if there is anything that they are uncomfortable with or do not understand fully, please engage counsel. You know, that's very important. We are not here to try to take advantage of anyone. That surface use agreement or right-of-way agreement or whatever, as you know, Brian stated, is a communication tool that communicates expectations, and the better we can address that up front and have that, you know, try to see through the full life of that well and address those expectations throughout the life of the well, the more likely that we are to avoid future conflict. And so, you know, we really want our landowners to be knowledgeable of the subject matter and be represented if they need to, so that, you know, we have something that is solid, because it benefits both parties to have a good solid agreement that to the best of its ability addresses all potential future situations. While that's probably impossible, we want to try to get as much as we can and really be clear in expectations and explain our operations and have that surface use agreement be reflective of that.
Commissioner Messner.
Thank you, Mr. Chair. And thank you for that presentation. That was a lot of good information, dense PowerPoint presentation. So I'm going to go back and read it again afterwards to make sure that I'm absorbing it all. But I did have just a couple of questions. You know, you talked about that CARES really focuses on kind of the larger multi-well pad development that minimizes surface impacts. I guess I was curious, what's the percentage-wise, and I'm talking just for CARES, of kind of those larger multi-well pad development versus perhaps some vertical single wells or some of that? I mean, are you mostly now doing those bigger multi-well pad developments, or is it still a mixed bag?
So currently, all of our current development plan is all large multi-well pad development. And again, we're generally in that 30 well range, some smaller, just depending on what we were able to reach and what reservoir has already been developed. But yes, we are solely developing on a multi-well scenario at this time.
Yeah, Zane, if I can add, small for us is 20. And because of the way the economics work out with like one-time costs of rig mob in and such, 12 or less starts to border on uneconomic.
Okay. And is that multi-well pad development or multi-well pad development also encouraged in the resource management plans from the BLM?
Yeah, so BLM is a big fan of co-locating, right, and reducing your footprint as much as you can. So that's a huge factor for us. That's stuff we use in our planning. We want to have the littlest impact out there. That's important to us as well as a company.
Sure. So, and I had asked this of TP, so I'm going to ask you as well. Like advantages, disadvantages of siting on private surface to access federal minerals versus federal surface to access federal minerals?
Yeah, to be quite honest, I don't know that there is any real advantage or disadvantage to either one. From our standpoint, it's generally we deal with the hand that we're dealt. We reach what we can reach from a location and go through all the other siting parameters, and the surface ownership maybe has less bearing on it. aside from, there are cases where we know that, hey, this surface owner is very unlikely to want to have this. And so then we would probably in that case err towards, if we have federal surface that we can develop from, we would go that direction. I know the example that Brian gave would be of a location where you had fee surface and then you were reaching onto federal surface. We also have true split estate where we have federal surface that underlies fee surface. So we are obtaining or accessing minerals that are directly under the fee surface that are federal minerals. And so, in those cases, and in many cases in some of our operating areas, we do operate on some large, or in our current development area anyways, some larger landowners where there really isn't that opportunity to pick or choose which surface we would come from if we are truly just accessing from what we are physically able to access from.
Sure, that's great, thank you. Then my last question was, I know that in the Piceance and Karis in particular does do a lot of more centralized production facilities, and therefore there's a lot of associated pipeline infrastructure for either produced water or for the gas itself. What type of surface use agreements occur around that associated infrastructure that may be different than like well pad locations?
So generally, if you were on lease, your on lease portion of your infrastructure would be covered under the surface use agreement. And then when you step off of lease and begin crossing off lease parcels or that are off lease to your wells, you would have right-of-way agreements that cover both your pipelines and your access roads and other facilities. And then in our case, and in some of the other operators, I'm sure we have compression facilities and water handling facilities that would be on a surface lease. And so while most of those other agreements are non-exclusive, they're actually very much designed that we're utilizing just what we need for our operations and returning that land to multiple use. A surface lease for a facility would generally be exclusive, where, for just obvious reasons of a compressor facility or water treatment facility, we couldn't have livestock grazing in it per se or whatever. So that would be an exclusive use of the surface. So that would be how those are handled.
And then, I guess I assume that the pipelines associated with this kind of collection systems, that probably doesn't fall under reasonable accommodation or access to minerals. And so, I guess, how do you work around potential surface situations where, a landowner doesn't want a pipeline to go across it, and you probably don't have another mechanism to force that to happen, right?
So yeah, that's an awesome question. And you're very correct. That doctrine of reasonable accommodation is directly tied to the minerals directly underlying that surface. And so as we cross out of that and cross over to another surface owner maybe, or are transporting minerals from off lease, that does become a right-of-way situation. And yeah, we can have an owner that says, no, I'm not going to allow that. And so then we are forced to find another route, another way to be able to do that. And that's, where that relationship with the landowners and conducting our operations diligently and prudently and developing a relationship with not just the landowner that we're operating on today, but with the community, and being able to, show that, hey, this can be a benefit to you, and we conduct our operations diligently, and helps in, hopefully allowing us that opportunity to be able to work through those and obtain that, right? But at the end of the day, yeah, they can say no, and then we're forced to find a way to work around that.
Great. I really appreciate the information and the presentation. Thank you.
Thank you, commissioners.
Other
Thank you.
questions from commissioners? Commissioner McGowan.
Thank you, Mr. Chair. And this is just kind of a more general question. When you approach surface owners, what do you think like the top 3 concerns usually are? I'm sure there's probably the same between surface owners about oil and gas development on their property.
So yeah, there are a lot of common themes usually. It does differ quite significantly from owner to owner, and then it's generally very tied to land use. So if we have an owner that it is on irrigated lands, those concerns are a little different than on rangeland. If we are in proximity to someone's house or something, that those concerns would be a little different. But I think surface disturbance and the revegetation of surface disturbance, weeds, noxious weeds that would arise out of that disturbance and things are a very common concern. Noise is somewhat of a concern, not maybe so much in the areas where we operate. We are generally, in our current development area, quite a long ways from anything really. But truck traffic is, I think, probably, if you asked every operator on here, truck traffic that's probably number 1. Weeds, dust, which would be a kind of a subcategory of the traffic, is another one. Truck traffic is probably number 1. Conflicts with trucks and other users of roads, dust, noise from trucks. That's probably one of the largest concerns, and one of the reasons why we do use centralized facilities to try to reduce that truck traffic, just for the safety aspect, the reduction of the impact to the environment, and to be a good neighbor. So weeds, truck traffic, and just disturbance, surface disturbance in general, I think, and reclamation would be how that's reclaimed, and then their ability to use that in the future is a pretty big one. But those would be some of the biggest concerns.
Sorry, Mr. Chair.
Yes, Commissioner McGowan.
And I guess I hadn't really thought about, and I hope this is an appropriate question, but if you're on someone's property for up to 20 years, is a surface agreement usually, I assume there's some sort of a payment because you're using someone's property. Is it usually a one-time payment, or is it like a 20-year lease for as long as we're on the property, we pay you something every year? Is there a typical way to set up a surface use agreement?
I think, as Brian said, while we have a form surface use agreement, there is no typical. And so in the concerns that are addressed and are important to one landowner are different. And then also the way that aspect is handled varies from landowner to landowner. And many times the way that is handled is somewhat driven by, whether that landowner also is a mineral owner. but there's a lot of factors that go into that. So to say, make a generalization would be difficult. It varies whether that is that owner wants that all up front, or we incorporate some of that into a rental so that they're continually, it really varies owner by owner.
Thank you. And I just want to thank all the presenters today. Like, this was very informative and super helpful.
Other questions for this panel? Okay, seeing none, I think we'll move quickly to our last panel. That is Laramie Energy. I think I saw Mr. Clark earlier with us and Mr. Hohenstein.
All right, can y'all hear me there? Good deal. Well, let me run through this pretty quickly again. Thanks, commissioners, for giving us a few minutes to go over our operation and cover a few things about the Piceance Basin. And thank you, Commissioner Gonzalez, for teeing us up with a few questions to help guide some of the things we want to talk about. So most of what I want to cover today has probably already been generally covered by the other operators, so we may skim over some things and reiterate a few other points. So if you go on to the next slide, please, Holly. So just an overview. I know it hasn't really been covered today, but Laramie Energy operates in the Piceance Basin. We've been here since about 2004, and we're a pure play operator. We've been operating in this basin in western Colorado now for nearly 20 years. As you can see, the basin map there really encompasses Mesa, Garfield, and Rio Blanco County. I've seen the number vary, but if you take the total resource, we are either the second or third largest natural gas basin in the United States. So a very significant resource here in western Colorado. Back in the peak of production in western Colorado, we were doing about 1.6 BCF a day out of this basin, and it should be noted again, this is a dry gas basin. It's 84% gas with about 16% NGLs. The primary operators, you've heard from two of them today, Terra and Karis, Laramie XTO, Utah Gas, and a few other Chevrons in the basin. I think we can probably go on to the next slide. I think we'll go on to the next slide. It's just a breakdown of Laramie's acreage position, and I wanted to make sure everybody kind of got a chance to look at that to show how much acreage we have, but most importantly, how much of it's fee and how much of it we happen to own as surface ourselves. So in total, we have just under 261,000 gross acres and 198,000 net acres. Of that, about 68% is federal and 32% is fee. And of that 32%, 26,500 acres is fee that's owned by Laramie. So a large portion, a matter of fact, the largest portions of our operations are either on our surface or federal surface, although we do have a lot of fee surface on independent fee owners also. Next slide. Just again, we just as Karis and Terra do multi-well pads. This is a view of one of our multi-well pads in the Colburn Valley area when you see the wells, the production equipment, and the tanks. And that would be a pretty standard setup for our operation. Next slide, please. This is a slide very similar to Karis's again. It just kind of shows the development in the Piceance. Primarily at this point, it's a Williams Fork development with these stacked tight sands developed on 10 to 15 acre densities with 16 to 30 wells per pad. Our standard well pad configuration is probably closer to 20 wells, 20 to 22 wells. If you look at that column there, you can see sort of the S shape and how the wells are drilled, which again is very consistent with what Karis showed. But also when we talk about the resource and western Colorado and the Piceance. The Mancos Shale, which lies below the Williams Fork, is one of the largest resources yet to be developed. There's about 60 wells, probably growing a little bit, in western Colorado, both vertical and horizontal, where folks have defined that resource and tried to refine the process. And now, once the Williams Fork's played out, a lot of the resource will yet to be developed in the Mancos Shale. Next slide, please. One of the questions that was on the list was really just kind of to define the timeline. And I think it's worth noting before I talk about anything on the timeline that every company is unique but the same. So the process and the timeline I want to throw out there is really Laramie's timeline for our development, and it's probably substantially similar to the others, but everybody has different nuances, different ways we develop, different schedules, and so on and so forth. So, I mean, I think it's been talked about quite a bit, but, before we even start permitting, we've got a 12 to 14 month development process, which can be quite extensive. We've got several of those going on now where we, evaluate the economics, the landowners, the stipulations. We go through a lot of the criteria for the alternative locations, the topography, and kind of put together a development plan. And then we launch into permitting. So, those numbers again are just off the top of my head because there is no real finite number, but you've got lots of permits to get before you can even drill a well. Of course, you guys are familiar with the COGCC process now and what that entails. As I talked about, a lot of our acreage is on federal, so we can have a approved resource management plan, and we have an approved lease. We go out and identify that it's either a leasehold well or a plan of development well. We've got to launch into NEPA, which is going to kick off an EA if it's a single well or a couple wells in a development, or not a development, but a wildcat type leasehold scenario. If it's a full plan of development, it might take a environmental impact statement, which ultimately hopefully results in a finding of no significance, a FONSI, and we get some approvals to move forward. But that whole process can take probably 6 to 24 months, is not even fair. 6 months would be very much fast track, and 24 months would probably be fast track for a bigger development. It could be many more years than that. And a lot of that's driven by the NEPA process and the complexities of doing timing, complexities and timing for many of the surveys and other field work that needs to be done. In addition to that, we still have, Corps of Engineer permitting if we have any water impacts for access roads and so on and so forth, CDPHE permitting for emissions and stormwater. So there's a lot of permitting that goes into the permitting phase of permitting a well pad. Not to mention, again, county permitting, and I know land use permitting is pretty much required in all of the counties. And in Garfield County, they also have a temporary housing permit, which can take a considerable amount of time. The pad construction is, once we've got to that point and we have an approved permit, 30 to 90 days probably. But again, that's oftentimes limited to the season of the year. We operate, again, in really tough topography and elevations, oftentimes up to 8,500 feet up on mesas where we've got significant winter generally. So we try to schedule our construction during, basically a 6-month window during the summer. So that can impact the timing also. When it comes time to moving in the rig, 5 to 7 days probably to move in a rig, and then we'll start drilling. So 5, 6, 7 days per well is probably a pretty reasonable average for the Piceance Basin here in western Colorado. And again, those are for Williams Fork wells. So that's 130 days for a 20 well pad. And of course, the drilling rig does operate 24/7. It's not a safe operation to start and stop, so you've got to keep going to maintain the integrity of your hole largely. And then another 7 days to demob and tear the rig down and move it off. Next slide, please. So I just wanted to put this out here before we go into completions, just to show that they've been happening for a long time. This frac job doesn't look like the frac jobs we see today, but this was an oil frac job in 1932 in Kentucky. So our impacts and process is a little bit different these days. Next slide, please. So I've got a errant bullet point there, so Lord knows what was there, but completions. So most of our wells, a 20 well pad would have 3, 4, 5 batches of wells that we would complete at a time. And before we move in to start doing completions, we have to basically install all of our production equipment, tanks, flow lines, get them tested, combustors, the whole pad basically has to be ready for production. I think there's a bit of a bust there because that's the same slide as before. So let's just go on to the next one. There we go. That production equipment is installed after drilling. So it takes about 45 days to get that equipment installed. Completion moves in, rigs up, and it's probably a 2 to 4 week process, or 2 to 4 weeks to get water lines set and get ready for completion. So a lot of times we'll lay temporary water lines. We've got to set in frac tanks, flowback equipment. So it takes a few weeks to get that infrastructure set up. And then we'll launch into completion. So typically we'll do 3 to 4 stages per day. That's in a 12-hour day. And each well would have 5 to 10 stages per well. So 100 to 200 stages per well pad. And it could take 30 to 60 days to do completions on an entire well pad. One of the things I wanted to talk about on that a little bit, though, is we typically only do 12-hour days or daylights for our completion process. A lot of that is driven by infrastructure and water demands. We recycle most of our water for reuse in our completions. And by allowing the wells to frack them during the day and flow them back during the night, we're able to capture that flowback water and then just recycle that water back into the process. So it greatly minimizes for us the infrastructure needs to supply water to do 24-hour operations. And then, of course, flowback 30 to 120 days after well completion. So all told, active construction, drilling, completion, flowback, it says 6 to 18 months. It's probably 6 to 24 months. Again, it just depends on the process and how we go about our completions. And again, every company does it different. Some do a centralized completion type process, as you heard today. Typically in our process, when things are really working well, we have multiple pads, and we would flip-flop the completions crew from one pad to the other. And again, that allows us to flow back more water and recycle that water, and just again makes for a more efficient process. Next slide, please. So again, you've heard a lot today about our SUAs, and I want to give one little caveat too, and I should have said this in the beginning, but in the agenda, it lists me as the VP of Land, and that is very much not the case. I'm the VP of Field Operations, and Jim Hohenstein, who's on the phone, is our VP of Land. So I'll cover the slides, but certainly the questions relative to land specifics, he's the guy that has the answers. But again, it all begins. You heard about the surface use agreement. That is it all begins with a good surface use agreement. So it's really a cooperative effort with the surface owner. Pad selection. Our typical pad would have a 5-acre flat working area, and then after interim reclamation, that would shrink down to 3 to 3.5 acres. We tried to minimize disturbance by putting pipelines in or adjacent to roads. We install gates and fencing as required to isolate the well pad, and then also provide for some controlled access, both for our operation and for the surface owner oftentimes. We have weed mitigation plans to meet not only the compliance obligations of the county, the COGCC, and landowner preferences. We do have some landowners who are organic and don't allow standard herbicides. So we have to accommodate those sorts of nuances. We again are in a very rural area. Noise mitigation is typically not required, although if it is required or it's something that the surface owner has a concern about, we will address that and either put in BMPs or mitigations, or oftentimes look at the siding of the pad to place it behind a hill or some barrier that would help with that noise. The exact same situation with lighting. Again, we're very rural, so lighting typically is not a problem. Of course, a well pad in production doesn't really have any lighting or noise issues. That's really mostly during the drilling and completion phase. And then visual mitigation. So that's, again, one of the things that we work quite a little bit with our surface owners through the SUA process. And they work with us collaboratively to try to site these pads and roads, oftentimes where they're out of their site if they have a cabin or a home in the area. The same with the equipment, whether we use a low profile type setup to minimize the height of the equipment and try to hide it within the topography of the pad. And then oftentimes we'll work with them and come up with different paint colors or paint schemes, again, to try to make the production equipment as hide it as much as we can. Next slide, please. So reclamation. And that's another thing that we really try to cover with our landowners in the SUA when we can. They typically always have input and oftentimes have ideas when it comes to seeding and vegetation requirements. Many of them would have a specific seed mixture that they would like to apply. In some instances, the landowners, being ranchers and natives to the area, are much better at growing grass than we are. And, that may be a condition of the SUA is that they get to revegetate and reseed around the pad or around the pipeline right away. Final reclamation, and I want to just visit with this a little bit today, and I know the other operators have brought this up also, but, final reclamation, we understand what the requirements are with the COGCC, but oftentimes pad retention, as it's been mentioned, is a big deal to the landowners, both pad and access road retention. And the landowner variance request is something I guess I'll get on my soapbox for just a moment. And I think it would be another great topic for this commission to have one of these sessions on and understand from folks what the landowners are requesting and what the difficulties we might be having in getting those approved. I know that oftentimes in our surface use agreements, we will provide the landowner with plats and access roads, and sometimes that's a condition of the surface use agreement or something that's specified by the landowner up front, is that they want you to put a well pad there because they want an access road so they can get to the back part of their property. And oh, by the way, we really want it because we know you're going to keep the snow plowed off it in the winter, and we have a way to get back to the back of our property, and so on and so forth. So, I guess it's just, I wanted to throw it out there and make sure folks are aware of that. And then the other main item that we cover in our surface use agreements would be what's going to happen with the pipelines once the well pad is done. And are we going to be able to abandon them in place, or are we going to have to remove them? So those are all things that we try to cover in the surface use agreement. Additionally, for protections for the landowner, we typically do base water quality, and we include the landowner always in those discussions. We might do their domestic well, we might do springs and creeks around their house, anywhere where they think they might potentially have an impact from our operation. So we always try to go out and establish and do baseline water quality, and then do follow-up water quality, and the frequencies are typically spelled out in the SUA. Sometimes it's annually, sometimes it's quarterly, sometimes it's periodically at their request. Next slide, please. So just wrapping up here real quick. The other things, again, for us, when we talked about, and I've seen the other presentations today, the concerns with our landowners are definitely different, I'm sure, than the typical concerns for the landowners on the Front Range. And in these SUAs, timing restrictions are one of the things that we have to tackle oftentimes. And, one of the questions that was asked earlier was, what are some of the biggest issues that the landowners have in these SUAs? And I would say for our operations, hunting and the ability to have access to hunting or the timing restrictions to accommodate hunting would be at the top of the list. And then, of course, accommodations for agriculture, grazing, crops, and we do some offsets and mitigations oftentimes to accommodate for those. Being a large surface landowner, we do oftentimes, or as needed, offer offsets and mitigations where we've offered either grazing or hay as an offset to damages in a hay field during a time when the landowner wasn't able to harvest their crop because we had ongoing operations. Hunting, again, with our private landholding, we've offered in limited instances for people who have guiding and other business on their property, to allow them to have access to our property to carry on that activity for a limited period of time while we might be impacting, their business and their hunting on their operation. And then, of course, the other thing that we end up doing and accounting for in the SUA would be negotiated damages, but those oftentimes are fencing. So we do a lot of fencing both on-site and off-site, irrigation system upgrades and changes to make sure that they're able to get their water and get it consistently. And we've also done some wildlife habitat enhancement projects. So again, may not at all be associated with that well pad, may be miles away in some instances, but still on that landowner's property. But we've worked with them to try to come to a consensus. And then just one last slide, I think. Just a little plug for community counts. And again, one of the things I wanted to throw that on there and just discuss that a little bit is, particularly in Garfield County, but all of the Piceance Basin. Again, we've been out here doing this now for a long time, Laramie since 2004, but the basin's really been active since 2004. And we've tackled a lot of these community problems with regards to notifications and stakeholder engagement. And all of the operators that you heard from today and all of the operators, I think, pretty much in the basin subscribe to community counts. And that's really one of their sole purposes and functions, if you will, is to work with the operators and communicate to the community and the landowners and the stakeholders significant activities, whether it be rig moves or frac crew moves or other heavy activity that might impact the community, and provide that for them. And it also provides they have a hotline where folks can call in if they have a concern or a problem that rings back to the operators and allows them to get in touch with the operators and get their issue resolved. And with that, again, just kind of trying to hurry through it there, but that concludes what I have for today.
Great, thank you. We appreciate all of this. Sorry you had to go last too, but appreciate the presentation. Do we have questions? I think we've run out of questions at this point. Thank you, Mr. Clark. Appreciate that. So with that, we are through the morning part of the agenda. We do have scheduled a lunch break followed by a wrap up by staff. We do have a bit of a scheduling problem. Staff wrap up was going to be done by Mr. Duranolo, but he has another engagement involving a dentist that he has to go to. And actually, I kind of think that might be a little fortuitous. I would like to give staff a little chance to sort of think through all the various, ways that Front Range and West Slope operators are doing this. And that might give staff a little chance to sort of spend some time, thinking through their notes that we've all taken from this. So if that's okay with commissioners, I would suggest that perhaps we do take our short 30-minute break to get some lunch. I know I would appreciate that. And then we would come back and wrap up with the supplemental environmental projects presentation from CDPHE. So it is 1:15, so 1:45. Great. See you then. Welcome back, folks. It's 1:45. We'll get started here in just a minute. Welcome, Mr. Helling. Thank you for being with us. Thank you for being flexible with regard to presentation time. I believe you are up. We are to hear a presentation on supplement environmental projects. So thank you for coming and participating with us.
Yeah, can you hear me and see me okay?
We can, yes.
Great. Yeah, thank you for having me and then inviting the Supplemental Environmental Project program to come and present. It's great to be here. So my name is Alex Helling. I am the Supplemental Environmental Projects Coordinator at the Colorado Department of Public Health and the Environment. So a lot of what I focus in on is this Supplemental Environmental Projects program. We generally refer to it as the SEP program or the SEP program. And is just logistically, is COGCC going to advance and present and advance the slides?
I'm happy to do so, Mr. Helling, if you prefer.
Yeah, that would be great.
We'll have, there we go.
Perfect. Great. Well, yeah, as I mentioned, my name is Alex Helling, and just again, thank you all for inviting me to come and chat about the SEP program. Go ahead and go on to the next slide. So, I like to start out fairly broad when I'm giving a presentation and kind of start to peel out the layers of the SEP program. So thinking about the SEP program, again, the Supplemental Environmental Projects Program, starting out fairly broadly. So within environmental settlements, regulated entities are required to generally achieve and maintain compliance with all applicable regulations. Most settlements include monetary penalties related to environmental damage caused and can also include an economic benefit the regulated entity has realized as a result of those violations. In some instances, so in some of these environmental settlements, regulated entity may offset a portion of that penalty by implementing a SEP. So SEPs are generally projects that benefit the environment and or public health that a regulated entity would agree to undertake in settlement of an enforcement action. But generally that, the regulated entity is not otherwise legally required to perform. So SEPs are always connected to and really come from these settlements around environmental violations with regulated entities. And SEPs are really an important component of the department's enforcement program, but they might not be appropriate in all cases, and we'll get into that a little bit later. Next slide, please. So starting off fairly broadly again, SEPs are generally voluntary, and CDPHE can't require a company to implement one. We certainly do encourage regulated entities to pursue SEPs in many cases, but again, they are voluntary. SEPs generally are required to create measurable impacts. So, these are oftentimes projects that would typically have a real tangible, quantifiable benefit. That could be projects that would, result in a certain amount of greenhouse gas emissions saved, energy efficiency savings, water efficiency savings, could be acres or miles of environmental restoration, like stream restoration, pounds of pollution reduced, and could also include other things like numbers of participants or general scope and reach of a project as well. But just to say, in addition to them being voluntary, generally they're projects that create measurable environmental or public health impacts. SEPs generally have a geographic nexus, is what we call it, where the environmental violations occurred. So this is generally county-based. So if there was an environmental violation in a settlement with a regulated entity in a certain county, the SEP would generally need to be implemented within that county, and we call that the geographic nexus. One bullet point that's not on this slide is there is not a specific media nexus. So if there's an air violation, that doesn't necessarily, there's not a requirement in the SEP policy that is an air project, or if it was a water violation, it would not have to be a water project. It could be an air project or an air violation with a water project, for example. That being said, there certainly are many cases where there is that nexus between the media violation and the SEP itself. And one additional note is, SEPs cannot be a project already initiated, budgeted for, committed to, or legally be required to be implemented. So SEPs really need to be projects that go above and beyond compliance and be, if not for, type projects that generally wouldn't have happened without those SEP funds. So this could be a new effort, or it could be an expansion of existing efforts, but generally something that wouldn't have happened without those SEP funds, that then creates that measurable impact in the county where the settlement took place. The next slide, please. So stepping down another layer, those are some of the kind of broad stroke requirements of the SEP program. They're voluntary, measurable impacts to improve environmental and public health. They're within our SEP policy, which really is the guidelines for the program in general. There's essentially 4 categories of potential projects. The first one being public health and safety. And public health and safety, although it's listed first on here, is actually one of the least common SEPs that we see. But they are generally a project that benefits more directly public health. And they could include things like prevention, screening, diagnostic or therapeutic healthcare, or educational offerings, or projects that really directly work to increase health equity and environmental justice as well. But again, public health and safety projects tend to be less frequent in the SEP program, and a vast majority of the projects are more on the environmental category side. So the second category, environmental education, these are projects that generally increase public awareness and knowledge about environmental issues and could provide the skills necessary to make informed decisions, take responsible actions. And generally an environmental education SEP would also need something like an action component, getting back to that kind of tangible, measurable benefits piece where it's both an awareness or knowledge increasing or capacity increasing, but also the component that's more action oriented. Pollution prevention or reduction. Pollution prevention is the category we tend to see quite a few projects in. And when we're talking about pollution prevention specifically, we're really thinking about source reduction. any practice that reduces, eliminates, or prevents pollution at the source through really a number of potential methods. And there's a lot of different kind of subcategories that we could go into the details to if desired for pollution prevention. You know, it could be things like renewable energy, like solar or wind, that is, you know, generally reducing the energy related generation emissions. It could be things like energy efficiency improvements, like home weatherization, that's generally reducing the amount of energy and having that impact on source emissions as well. So again, just pollution prevention is one of those categories that we tend to see more frequently. The second piece of that, pollution reduction, is another category that's less common. And the differentiation here is that for pollutant reduction, we're really thinking about where a pollutant or waste stream already has been generated or released. The pollution reduction approach would generally be looking to reduce that pollution once it's already left the source, versus pollution prevention, which is generally the projects we do more of, we see more of, are actually looking at the source reduction instead of or the source prevention instead of reduction. And then the final category listed on the screen, environmental restoration. We tend to see a good number of environmental restoration projects as well. And really the objective of those projects is to repair damage done to the environment beyond the need to remediate any damage caused by a violation. So projects that benefit multiple media types are great as well. And, you know, we see a variety of different projects. You know, the image on the bottom left there is a great example of a project implemented by Volunteers for Outdoor Colorado, where that's kind of a combo environmental education volunteer program where they're working with volunteers to restore natural systems in Weld County. And that middle image is some groundwork Denver SEP work around home weatherization, and that bottom right being a solar installation in Weld County as well. So just again, fairly broad strokes again, but these are the SEP categories generally that if we're talking about the SEP program, projects that are eligible would generally need to fall into these categories. Next slide, please. So SEPs can ultimately provide additional environmental or public health benefits in communities affected by violations that go beyond those achieved by compliance with applicable laws. And it's really great when those projects that go beyond compliance also overlap with some of the department's missions and goals. So when discussing multiple potential projects, and we'll get into more of the process side of the program a bit later, we really like to think about a preference for projects that help further some of those goals, like health equity and environmental justice, pollution prevention, which is also one of the earlier categories, and climate change. So we really like to see that overlap when there's a great project coming through that goes above and beyond compliance, as all SEPs must do, and also overlapping with some of these really important priority areas as well. We also take into consideration other factors like innovation. The nature of the SEP program is that we are able to work with some of those more innovative projects that meet all of the different details in the SEP policy, or the requirements in the SEP policy, and can really have that, preference for those really innovative projects that really help to move the needle in a newer, novel way. Cross-media impacts are great as well. If we can find projects and, or if projects can go forward that really, are not just addressing, air media, but also air and water, or if we're talking water and waste, that's also another priority area. And then also just community input as well, kind of tying back to the preference for environmental justice projects. The greater a tie-in we can have between, meaningful involvement of the communities and community members in areas where violations may have occurred, and being able to incorporate their guidance and feedback into the projects that get implemented is a priority as well. Next slide, please. So going a little bit deeper again, there's two primary types of SEPs. So when we're thinking about SEPs in their general intent, there's two primary mechanisms that SEPs kind of go through. One is being a first-party SEP, and the other a third-party SEP. And a first-party SEP is generally one that would happen within a regulated entity's facility that goes above and beyond compliance, whereas the third-party SEP is a regulated entity that is essentially the SEP money is going towards a third party that's eligible, 501c3 nonprofit or a governmental organization to implement that SEP. So there's an important distinction to keep in mind as far as a first party SEP versus a third party, where the first party is happening within that regulated entity's facility and the third party is happening outside of that in the county. And there's a number of different details that I'd like to highlight as well within this. First party SEPs are held to a higher standard of integrity and quality, and are really only considered for regulated entities that are really responsive in their interactions with the department. As I mentioned earlier, SEPs are not appropriate in all cases, and first party SEPs specifically may not be appropriate in all cases. Like if there's a regulated entity that's less responsive and more, or may have a history of being a little bit more challenging to work with. There's a lot of more requirements that are deeper, more robust requirements in the first party SEP, since it is a project happening within that facility, that we really want to make sure that that project will be implemented and we can have those have a good relationship with that entity that's implementing that SEP. One of the pieces within a first party SEP is what we call the penalty mitigation value, and this is one important piece to keep in mind. So essentially, first party SEPs often include this penalty mitigation ratio, which essentially is the amount of SEP that would be required to offset a certain amount of penalty. So if you were talking a 1-to-1, if you had a $100,000 penalty, you would implement a $100,000 SEP for a 1-to-1 offset. For a first party SEP, it's generally required to be a 1.5-to-1 or higher ratio. So if you're offsetting a $100,000 penalty, you'd need to have a SEP that's $150,000 to fulfill that 1.5-to-1 ratio. It could also be a much higher ratio. It sometimes has been 4 or 5 or higher. And that gets back to that, sometimes SEPs aren't always appropriate. So that's all part of the conversation and negotiations with that first party or that regulated entity to really land on a good project and the different parameters of that project. So that's just one thing to keep in mind specifically when we're thinking about the two types of SEPs. For first party SEPs, when we're talking mitigation value and mitigation ratio and how much of that penalty you're offsetting, for a first party SEP, it's above a 1-to-1 ratio, but for a third party SEP, it tends to be that 1-to-1 ratio. So thinking about first party SEP, third party SEP, and we can go more into the weeds if we'd like to as well, but I don't want to go too far before moving on. Main things to keep in mind is that a first party SEP happens within the regulated entity's facility, tends to be a greater mitigation ratio than for a third party SEP versus the third party SEP that happens with an external entity implementing a project, generally with that 1-to-1 ratio. And that image here on the right is something that relates to the third party SEP, and this is what we essentially call our third party proposal or SEP agreement form. And this is a pretty common form that we work with that generally just captures all of the information that either a first party SEP or a third party SEP would be looking to implement. Next slide, please. So within the third party SEP world, a couple things I wanted to highlight, and third party SEPs tend to be fairly more common than first party. Within third party SEPs, in these instances, the regulated entity as part of that SEP agreement essentially is sending those funds over to this third party SEP administrator, they're called. And those entities must be a 501c3 nonprofit or a governmental agency. And generally, the eligibility, being that type of an entity and also having the project that ultimately gets funded be one that meets the, those SEP categories and all the other components within the SEP policy. There's a lot of benefits to third-party SEPs and the SEP program in general that I also wanted to highlight as far as, whether it's a first-party SEP or a third-party SEP, whether it's a regulated entity implementing it at their facility or if it's a third-party implementing it, I like the program because it can encourage innovation. It's a great way to help fund innovative projects that are kind of wish list type projects, but are also shovel-ready, that would likely not have happened otherwise, but really can enhance environmental quality and public health and really help move the needle. They can also provide some restorative justice in the sense of these projects are happening in the county where these violations occurred. So you can have that kind of responsive nature of the SEP where it's occurring in the area where those violations were. I think we're also leveraging penalty funds for positive impacts and helping to identify, those really positive projects in response to those violations that really get at that enhancement of environmental quality and measurable enhancement of environmental quality and public health. Next slide, please. So, when I'm putting together this slide, there's not one clear way to really go through identifying potential SEPs, but I, put together this slide to help differentiate some of the different processes. And when we're thinking about kind of big picture, narrowing in, generally there's the SEP program. They're looking to provide these environmental and public health benefits. They can either be a first-party SEP or they can be a third-party SEP, and there's general requirements within those. As kind of the broad strokes of the program, one of the big questions that I'm often dealing with is how do you identify the potential projects? It's a great program, but they actually have to be implemented as well, and somebody has to be able to do them. So it's a big part of my job of helping to identify those potential supplemental environmental projects. And there's a couple different avenues that this happens through, and I put together this slide just to help differentiate those different avenues. And I know it splits it out between $750,000 above or below, but that's not a hard and fast rule. It's just a helpful way to kind of break it out so that we can think through the different avenues of identifying potential SEPs. So starting on the left and kind of moving to the right, again, for first-party SEPs, there tends to be more of a direct negotiation with that regulated entity that had that there's a settlement proceeding with. Generally, since this is within that facility, it's a kind of a conversation about the SEP policy, potential projects, and things like that mitigation ratio I spoke to earlier, where you're really chatting with enforcement staff, the regulated entity, and myself to try to identify what a good project would be, what the parameters of it would be, how much would need to be expended to offset a certain amount of the penalty, and generally making sure that all of the components within the SEP policy are met. So for that first party SEP that I mentioned earlier, direct negotiation is generally how you come up with your potential SEPs. Since it's generally within that one facility, it's a relatively smaller conversation, but it's still generally pretty complicated as far as what beyond compliance type projects are able to be implemented. So moving over to the right again, for third-party SEPs, generally we work with what we call the SEP idea library to help identify the potential project that would be funded as a result of those violations. And the SEP idea library is an important piece because there's always a little bit of a challenge with the program of having those shovel-ready kind of wish list like projects, but never knowing exactly when a certain enforcement will be coming through. So they need to be those shovel-ready wish list type projects, but they may not also happen for a year or two at a time. So when there's a decision to fund a third-party SEP, we go into what we call the SEP idea library, where different potential and eligible SEP administrators have essentially submitted those projects as kind of pre-screened, not necessarily pre-approved, but pre-screened projects that then enter in the conversation once that third-party SEP is being approved. And I'll go into a bit more details for how that SEP idea library functions and how we get ideas in it as well. And also just to highlight that kind of in the third column on the right is when there are SEPs that are $750,000 or more, the department encourages and supports the use of what we call the SEP community process. And this is really a formal competitive process in which applicants would respond to a request for SEP proposals or essentially like an RFA. So instead of that direct negotiation or pulling ideas from the SEP idea library that we're constantly updating, this is essentially building a new list of potential projects from kind of the area where the project has happened. So it's much more responsive to that specific area. And we're essentially doing a community process to build the request for applications, information, materials, and criteria, and then putting that out there and then having the proposals come in response to that. And that's how we get the potential SEPs for those larger SEPs. And as I mentioned earlier, for SEPs over $750,000, we encourage the SEP, the community SEP process, but it's not required. Ultimately, if a regulated entity could opt to pursue a first-party SEP or the generally working through the SEP idea library as well. But we do frequently encourage the use of that community SEP process for those larger SEPs as well. And I'll go into an example of one of those here in a little bit. So moving forward onto the next slide, I just want to provide a little bit more context for a couple of those pieces. One of the areas that I wanted to highlight is this essentially submitting a SEP idea library. So if you are if you're an eligible 501c3 nonprofit or a governmental entity, you can go to this website and essentially submit an idea or a SEP proposal essentially for the SEP program that I would generally work with that entity after they submit the idea and see if it meets the general screening requirements. And then if it does meet that minimum eligibility, it would go into the SEP idea library as part of the kind of the future conversations for different SEPs that could be funded. So this is an important mechanism that we have that, if you're an environmental restoration nonprofit and you have some, wish listy type projects that you would love to fund if funds became available, and it's relatively shovel ready, I could work with that entity to submit that idea, and then it would go into the SEP library. And then when that, violation occurs, and then if a settlement comes from it with a SEP, then we can pull out those ideas from the SEP idea library and then pursue implementation of them. So this is just one piece to highlight that helps to generate that SEP idea library, which is a really important piece of the SEP program. On to the next slide, please. So I just pulled out two quick examples of what's captured in this SEP idea library, because I think it helps to contextualize some of the information that we're holding for when potential SEPs come down the pipeline. So generally speaking, eligible organizations can submit their ideas, but there's no current mechanism for members of the general public to submit SEP ideas outside of working with those eligible organizations, the nonprofits or the governmental entities or local governments. So I generally encourage organizations to submit SEP ideas that are, again, those wish list type projects. If I called you in a week or next year, you could accept and then kind of utilize that funding pretty quickly. So we ask for a number of details within those SEP proposals that we then hold on to in the SEP idea library for up to 2 years. The title of the project, the organization, a list of the counties where the project could happen, the range of dollar amounts that would be operational, that the organization could operationalize, in addition to the general description of the project and what the expected benefits would be. The idea being that if we have a settlement that comes down the pipeline and say it's in Weld County, it's for $100,000, we can go to this idea library, we can put in Weld County, all the Weld County projects will pop up that could be implemented in that county, and then we can look at the potential dollar range for those projects and then pull out a few potential projects that we then work through to identify the actual selected project. So this is a very important, helpful tool that we maintain of these different potential projects, so that when a SEP is coming down, we're able to pretty quickly pull it off of the shelf of the SEP idea library and move it into implementation pretty quickly. Next slide, please. So, stepping back a little bit and just trying to re-summarize and contextualize this a little bit further. Ultimately, the SEP program comes into play once this, once there is a decision made to fund a SEP as part of a settlement. And then there's either a third-party SEP or that first-party SEP kind of pipeline that you'd then go down. For the third-party SEPs, you work through that SEP idea library and discuss with the regulated entity and potentially the third party and the enforcement folks as well. Versus the first-party SEPs, you're really negotiating that project with the regulated entity and enforcement more directly. So you get the decision, you kind of split off into either a third-party SEP or a first-party SEP, and then you kind of come back together into the space of, if it's a SEP over a certain amount for $50,000 or more, it must be approved by the Director of Environmental Programs at the department as well. So now we're at this point where we have, a SEP that is part of the settlement. we know it's either a third-party SEP or a first-party SEP. So then we formalize the project activities, the benefits of the project, the budget of the project, the timeline, really all the details necessary to capture what would happen in that SEP into what we call the SEP agreement. And it really mirrors that form on an earlier slide. All of the regulated entity and enforcement staff and myself generally sign off on that SEP agreement, and then it becomes that fully executed document that I then work with that SEP administrator, whether it's that regulated entity doing a first-party SEP or the third-party SEP administrator to track implementation, generally assist, and then document and approve completion of that project. And an additional piece that can sometimes come up is if something unexpected happens, like COVID, that really impacts kind of everybody across the board. If there's ever, issues that arise with a project, they need another month or they need a little bit more time to complete a certain project. I would generally work with all the parties involved to help kind of coordinate a solution to that, whether it's a modification of the SEP agreement or whatever's necessary to kind of resolve the issue. So kind of bookend to bookend, starting with the decision to fund a SEP as part of a settlement, breaking off into the third-party SEP or the first-party SEP, generally getting approval from the department if it's over $50,000, and then formalizing either that third-party or first-party SEP into the SEP agreement. And then I would generally work with that SEP administrator to track implementation and verify completion as laid out within that SEP agreement. Next slide, please. So that third track that was on that flow chart earlier is the SEP community process. And this is definitely a different kind of a pathway that we follow when looking at what SEPs would be funded through a settlement. So the example I wanted to highlight was in March of 2020, there was a settlement with the Suncor refinery in Commerce City that also had a $2.6 million SEP component to it. And we've been working through a new community process since, I want to say, May of last year to really kind of center the perspective of the communities in the area in how these SEP funds should be used. So we've been doing quite a few different types of engagement, from one-on-one conversations to focus groups and larger community meetings to phone calls to seniors that don't have digital access. Really trying to first build the request for applications materials and the different criteria that are captured in that RFA document. Kind of front-ending that community engagement piece to make sure that the projects that come in are mirroring what the communities in the area might be looking for. And a second big component is forming an evaluation committee from that community engagement process as well. And that evaluation committee, including, for this case with the Suncor SEP, 9 community members from the area, in addition to a Suncor representative and a CDPHE representative. And so there's kind of these two components of that SEP community process in this instance, where we're really building that RFA and bringing in a pipeline of projects that are desired, and then having an evaluation committee with a majority of community members in the area that are actually helping to make the decisions for which of those projects would get funded. So we're really taking more of that meaningful involvement component of environmental justice and applying that lens to this this community SEP process. And ultimately, the committee makes those decisions on the funding from those applications in response to the RFA. So kind of thinking about this within the context of the other parts of the SEP program, generally we build this RFA, and that's how those SEP ideas essentially are coming in, and then the evaluation committee is evaluating those ideas that come in and making the decisions on which ones would get funded. And then we kind of return to the same track of, then I work with those SEP administrators that get funded to track implementation, resolve any issues that might come up, and generally document completion. So, just to thinking about it in those 3 different categories, the first party, the third party, and then the SEP community process, they're all just different ways of identifying the different SEP that would be funded as a result of that enforcement action. And there's different cases in which the different options would be used. Next slide, please. So stepping out from kind of the different parameters and details of the SEP program, I just wanted to display a few of the kind kind of summary details from 2017 to 2019 for different SEPs that have been implemented. And this certainly is not exhaustive, and I can send around, if useful, more details on these projects. But generally, you see a trend from 2017 to 2019 of increasing kind of dollar amount for SEPs, and I imagine for 2021 that will be similar, given the $2.6 million SEP from the Suncor refinery alone. There's two things I wanted to point out within this, because I know it's just kind of generally capturing different categories for projects that have happened. One is that we tend to see some similarities in projects over time. We do see a lot of energy efficiency type projects, a lot of renewable energy type projects, kind of getting to that focus on climate change and pollution prevention. We see quite a few of the environmental restoration projects as well, with a number of those focusing on kind of the intersection between volunteer engagement and environmental restoration as well. But we also see a number of one-off SEPs as well that kind of gets at more of the innovative space. One example from 2018 was a comprehensive training for regulated asbestos contaminant soils. Essentially, it was the regulated entity put together a comprehensive training video that would then be used by others to better understand kind of the asbestos contaminated soils regulations and different requirements within that, kind of getting at the environmental education type project. To a 2019 lead hazard control project that I hadn't seen previously. So just to capture that, we do see general trends in a number of different types of projects, but we also see a number of one-off SEPs as well that are not necessarily unexpected, but they're not the same ones that we see routinely throughout the year. Next slide, please. So just to add a bit more context as well for some more specific examples. So this SEP specifically by Clean Energy Economy for the Region, or CLEAR in Garfield County, provided free energy coaching, energy efficiency upgrades, and HVAC maintenance services to low-income residents in Garfield County through the Garfield Clean Energy Challenge for Homes program. Residents also received assistance in applying for available rebates from local utilities and other potential programs. Where structural or health and safety concerns were observed, CLEAR connected residents with appropriate community assistance as well. So I really like this type of SEP because it ties in a number of, it clearly fits within the pollution prevention category, but it also ties in climate, it ties in equity, ties in lowering bills for residents. And you also still get some really quantifiable data at the end of it of, as far as metric tons of CO2 saved, the amount of energy saved, and also the annual cost savings to the residents that participated in the program. So I want to display this example as, it's not a huge SEP, but it generally can provide quite a bit of impact and really hits a number of those priority areas that we tend to have a preference for. Next slide. So another example, this project at the University of Northern Colorado in Weld County. So, installed a 172 kilowatt solar PV system on Parsons Hall in Weld County. So this was a fairly cut and dry SEP to implement and install a specific piece of equipment that fits into that pollution prevention category. In this type of project, a solar array installation is, we see them relatively frequently, and I think it's one of those kind of wish list, shovel-ready projects that has clear benefits and can really tie into environmental education as well. One of the components of this project was, it really built on UNC's sustainability and energy efficiency efforts and included those environmental education elements for students as well. In addition to just the quantifiable data that was reported out as well, with again the saving in electricity costs, savings on kilowatt hours, carbon emissions. So just another example of a potential SEP. And for one more example on the next slide. So this is a SEP that is ongoing right now with the organization Volunteers for Outdoor Colorado. I like this example because it has four interesting components that all work really well together and tying together environmental restoration and education. So for this SEP, VOC looked to hire and implement a volunteer and partnership coordinator based in and serving Weld County and the near vicinity to support build out of a volunteer and partner network in Weld County. As kind of the first part of the project. Also included planning and managing priority volunteer stewardship projects for 2 years in Weld County, offering outdoor stewardship trainings to expand the volunteer base in the area, and also build a strong network of organizational partners in Weld County committed to ongoing outdoor volunteer stewardship, including helping to host 6 partner convenings. So I really like this as an example because it's clearly something that would not have happened if not for the SEP funds, but is a really great example of kind of a force multiplying to work towards one of those SEP categories of environmental restoration. So those are just 3 examples of past SEPs or an ongoing SEP that I wanted to highlight. And then one final slide here. So I know one of the questions of interest had to do with CDPHE authority to require SEPs. So I just wanted to touch on that briefly as well. So there's no specific state statute that authorizes the department to engage in SEPs. Rather, the authority to engage in SEPs is under the division's direct enforcement authority delegated by the EPA. So ultimately, SEPs are voluntary and we can't require a company to implement one. They are subsequently included as part of the settlement agreement and SEP agreement, and then they become binding since they're required as part of that settlement process. And there's the Air Pollution Control Division, the Water Quality Division, and the Waste Division. My work with them, there's different processes in the different divisions, but generally all include that SEP agreement piece as well. And once that's signed and fully executed, then it becomes part of that settlement agreement. So that's my general rundown on the SEP program. A little bit of a crash course, but I did want to get through it so that there was plenty of time for any more specific kind of digging questions, just to make sure that whether I can hopefully provide an answer now to any additional pieces of interest, or I can look for more information and get back to you all as well. And if you want to go through just a general questions one.
Thank you for the presentation. A lot of really good information there. I just had kind of one general question, and I think you actually just answered it on the last slide. As you were going through the SEP program and talking about the categories of SEPs and the first party SEPs and the third party SEPs, I had written down a couple times, is this authorized by statute, or is this just something that CDPHE put together because you have enough enforcement activities that it was a good use of those monies?
Yep. So there's no specific state statute that authorizes the department to engage in the SEPs. It's that general enforcement authority delegated by the EPA.
And then it's the volitional agreement of the entities who are being enforced against to agree to do one of these as opposed to just paying a penalty.
Yep. So instead of that penalty being paid to the general fund, at least in the cases of the Air Division and the Waste Division, that goes to offset that penalty via SEP. There is the, if we want to, I don't know if I want to go down the rabbit hole of the Water Quality Improvement Fund, but that, the Water Division does have that statutory piece for the Water Quality Improvement Fund where penalty dollars go towards that. So there's a little bit, there can be a different conversation there because those funds can, through the Water Quality Improvement Fund, those penalty funds through the Water Quality Improvement Fund also fund environmental projects versus the Air and Waste divisions. Those funds generally would go to the general fund.
Great, thanks for that follow-up. Looking to my fellow commissioners to see if we have questions. Commissioner Gonzalez.
Yeah, thank you very much, Mr. Helling. I really appreciate the presentation. And I had spent some time on the CDPHE website looking at the SEP website and some of the basics that you kind of covered here. And I was curious, are SEPs an appropriate mechanism in all or in certain circumstances, and are SEPs favored over a monetary enforcement penalty? Just trying to kind of reconcile when SEPs are used and when they may not be allowed as options.
Sure, and they're definitely not appropriate in all cases. One of the pieces is that negotiation place where if we're pursuing, say, let's go down the first party SEP perspective, because there are more kind of considerations that come into play for those first party SEPs. There's things like potential economic benefit that would need to be mitigated through the SEP. There's the mitigation ratio. So there's more general negotiations and things like that need to take place. And generally, we want to have that solid working relationship with the regulated entity to make sure we can make sure that the SEP would be implemented as agreed to, because what this can expand kind of that enforcement timeline. You're not just sending that money to you're just not just paying that as a penalty. You're implementing a project for 1, 2, or even longer years at this point. So that's one thing that comes to mind for me, as far as we really want to know and have a good enough working relationship so that we can develop a quality sound project in that SEP agreement and know that it will then be implemented, and that we'll have that ongoing relationship to be able to document the expenses that go to it, and generally be able to verify that it occurred. As far as the negotiation side of it, and when it's appropriate to incorporate it in, the actual negotiations for the settlement, I think that would be more of a conversation that I could check in with for the, enforcement staff, because I tend to enter the conversation once the conversation of a SEP comes up. And if, kind of the preliminary conversation where it's, should we even entertain the idea of a SEP within that settlement agreement, I'm not as involved in that process. So, more details on that, I would want to defer to the enforcement folks that are more on the development of the settlement side.
And that's fair enough. So that's fair enough. This other question may fall in the same category, but I'm going to ask it anyways. You talk about that the SEPs may not be for a project that has already been initiated, budgeted for, committed to, or is legally required. And I'm curious if that legally required concept, if that includes, above and beyond legal requirement. Let's say, hey, this is something that's legally required, but I'm going to go do it, to a greater extent, or I'm going to accelerate it, or I'm going to do it before I'm actually, required to do so.
Great question. I'm curious if you can have a specific example that we could kind of talk through, because, I think generally, a settlement will require, getting to compliance with any, environmental regulations and compliance requirements. And then the SEP would help to take things above and beyond that compliance. So, I think I tend to see it as that line where generally these are things above and beyond compliance, and those activities would not help get to compliance. They would have to be kind of separate from those compliance related activities. Does that answer the question?
It does. It's a tough question to answer. I know. And there's a couple scenarios that we're facing as a commission, maybe not facing, but there's situations out there where an operator may be required to do something through an enforcement action. They say, hey, well, I'll do this and I'll do this extra if I can, work that in the negotiation. So I'm just curious how that works on your end, but I get that it's what it seems like it is a case-by-case kind of part of the negotiation and enforcement side of things.
Yeah, but I do think that generally speaking, and I think there's always a little bit of a digging into the weeds to see what's appropriate or not. But I think generally, SEPs aren't for anything that's compliant. So if it's above compliance, it's a clear-cut case of they've already done the necessary steps to get into compliance. And if they want to do a SEP in addition to that, that would kind of be a part two in my mind, because there is that there's that distinction between, generally can't be something that was required already. It could be a parallel piece, and that's how you generally see it in the settlement documents, is when you're laying out the requirements within the settlement. There might be a monetary penalty, or there might be compliance related improvement requirements, and then there might be a SEP as well. So it's generally part of that general settlement package.
Thank you.
That was a tie. I'm going to give the tiebreaker to Mr. Messner.
Yeah, thanks for the presentation. Love the information and the concept. But I'm going to ask kind of a sticky question. I think I heard you say that the penalties go to the general fund if it wasn't a SEP, right? Perhaps never to be seen by CDPHE again. if they didn't go to the general fund and they were able to be kept by CDPHE for some other use, do you think that they would be as palatable, or would CDPHE be as interested in utilizing the SEP process if they were able to keep and utilize the penalty funds?
Can you rephrase that one time? I just want to make sure I'm fully understanding your question.
Well, right now the penalties come in, and you can either do a SEP, which CDP has some control and guidance over for beneficial use, or they go to the general fund to perhaps never be seen by CDPHE again. If the penalty money didn't go to the CDPHE, and the example I'm utilizing is right now penalty funds for NOAVs for COGCC comes into the COGCC budget as an enterprise fund, right? However, at CDPHE, they don't. If it went to your budget, would you be interested in seeing these funds be utilized for SEPs, or is it more beneficial for CDPHE to utilize the funds themselves?
Okay, so generally, almost like if there was a different mechanism entirely where it was more of a generally to CDPHE instead of general fund or SEP, is that correct?
Right.
Gotcha. Ultimately, I don't know if I have a big enough picture of all of the environmental activities at the department to be able to answer if SEP versus something else is more appropriate. I think that's a question that I would need a little bit of internal conversations to be able to answer effectively, to be honest.
Fair enough.
Could I take a crack at my perspective on that, if I could? So in general, funding from violations can't be used to support a program or FTE. One, because of conflict of interest, and two, because it's from year to year, you don't know what the violation amount is going to look like. And so even if, for example, the water penalties do go to a grant fund over at CDPHE to support local communities that need to improve their infrastructure. And so it still supports a program, but it supports a granting program that doesn't really, it benefits CDPHE in that we're going to have improved water infrastructure throughout the state, but there's no direct benefit to CDPHE. And I think likewise for us, the commission, the funds are being used to help support the orphan well program, and I'm not sure what else, but it doesn't support and cannot support FTE or a specific program that we might have, I don't think. And so I think because there's that limitation, I think that the trade-off in being able to use it for a beneficial project in a community or for something that's important to the commission to move forward, but we haven't had funding for in the past, that's why that's compelling to me. And so we're not having to choose between Peter or Paul.
Sure. No, that's fair enough. Because my second part of that question is, can CDPHE initiate a SEP, right? So could CDPHE say, we need this piece of equipment for the air quality control division or air pollution control division. I'm going to put in this SEP for a beneficial utilization of this.
So generally, CDPHE doesn't recommend specific projects. We work with those either regulated entities to identify those first-party SEPs, or we maintain that kind of catalog of those third-party potential SEPs. We don't generally recommend specific projects. We generally wouldn't implement a SEP. Kind of a little bit along the lines of one of the pieces that Karen was mentioning. So I think, so generally we don't recommend specific SEPs.
Okay.
Could you though?
I think generally I would need to dig into that a little bit deeper. I think what I've seen in my tenure as the SEP coordinator is that it's not something that we have recommended specific SEPs. I would need to dig deeper into that one, which I'm happy to as well of could we or not.
Great. A couple more questions if I could. Do you allow operators to do in-kind in lieu of actual dollar amounts as part of these SEPs? So example would be, I'm an operator. I've got a bunch of equipment. I'm going to go do, you know, $250,000 worth of you know, dirt work for part of this environmental project. Is that an appropriate SEP?
Yeah. So, and one of the slides I had, there was first party SEPs and there was third party SEPs. There's technically a third category that is very uncommon. What's essentially called a first party to benefit a third party SEP. As I mentioned, it's very infrequent, but you know, it tries to get at that type of intent where essentially it would be a first party doing something to benefit a third party. So it could be more of that in-kind type piece. We do. In my term as SEP coordinator, haven't seen one. That's how infrequent they are, because it's pretty challenging to kind of document and track the expenditures through something like that. You know, how do you adequately document that somebody's doing that work specifically for that specific project versus their normal course of operations, especially if there's like equipment that's being obtained or anything like that. So, you know, it is technically one of the categories, first party to benefit a third party, but it is very uncommon from what I've seen.
Last question. I think I heard you say that an operator could split a penalty, so they're going to pay half of it in cash and then do an SEP for half of it. Is that right? So it doesn't have to be all or nothing.
Generally, it's not all. So generally, it wouldn't be the full amount. 80% is the common number. It could be a different amount as well. That would generally be part of the discussion on the settlement side of things.
Okay. Thank you very much.
Other questions from commissioners? Commissioner McGowan?
Mr. Chair, and I think I know the answer, but I just wanted to make sure. There is some flexibility in how you can set up your SET program, correct? So if another state agency you might have delegated authority from EPA wanted to limit its SEPs to a certain type of category or purpose, could they do that?
You know, I think that would be within the delegated authority. You do see differences from state to state as far as the different you know, parameters and kind of workings of the different SEP programs. So I think that would be you know, from my perspective, that would be a conversation that could be had as far as you know, changing up the SEP policy, changing the different categories that might be in there. You know, you can also have the different processes. Like if you're doing a you know, a community process and you're building an RFA, you could have different priority categories that would more focus on specific types of projects. So I would say that generally speaking, you know, within the general delegated authority, there is you know, the SEP policy has changed over time from I believe, and you know, especially within that perspective of the SEP policy and the RFA, you know, there's different you know, priority areas that you could call out.
Further questions from commissioners? All right, seeing none, thank you again for the excellent presentation and for sharing some of the information that as CDPHE deals with its SEP program. Very good information for us.
Yeah, I really, again, appreciate all the commissioners' time to listen to the presentation and really great questions. You know, just full disclosure on my end, I've only been the SEP coordinator for about a year and a couple months at this point. So there are pieces that I'm still learning. And if I didn't adequately answer any of your questions, I'm 100% available to dig deeper into a fuller response. Just to put that out there, that I am very comfortable with getting follow-up questions that were the same questions that were asked here, and I'm happy to dig deeper into getting a fuller response if useful.
Okay, great. Well, I appreciate that. One of our commissioners is going to be listening to the presentation a little bit later, and if they have questions, we can certainly get back to you. I know we generally kind of go back over our notes and we have questions, we know how to reach you. So thank you again, Mr. Helling, for volunteering and being able to present to us.
Yeah, thank you all.
All right, commissioners, with that, we move to the next item on our agenda, which is the consent agenda. knowing that consent agenda item 2007-00176 Bowen versus CWC Petro is off of consent agenda. So we only have the other two items, 2006-00156 and 2006-00154. Before we take up consent agenda, I generally like to ask if we have any questions from commissioners to staff concerning consent agenda. Commissioner McGowan.
Thank you, Mr. Chair. And I think my questions are similar to the ones I had last week because they're similar issues. And again, I'm trying to teach myself to fish, so I'm going to caveat that the information might exist and I might not be finding it the right way. So for 31 Operating LLC, I did try to look up in COGCC whether or not they had been submitting their monthly production forms, and I don't see anything since October of last year. And I'm just checking in with staff to see if that's correct, and you don't have to answer it today, but I think it's something that we need to keep our eye on again. If operators aren't paying their mineral rights leases, is that what we would call them? And they're not turning in their production forms, that's concerning to me. And it also looks to me like they have some outstanding NOAVs that have not been closed out that we've been working on for a while with them. And if staff could get back to me on that as well. They're just, again, just kind of little red flags to me if we have operators who are not paying their mineral leases. And then if I look further into and see other issues, I just want to make sure that we've got operators in good standing who are doing the right thing.
Deputy Director Cuthbertson, I see that you've unmuted.
I would just maybe offer that your observations, I think, are accurate, Commissioner McGowan. And there are a number of NOAVs that are progressing through the system for general non-compliance. I mean, compliance is always our objective, and enforcement is the last tool in that toolbox that we go to when an operator doesn't come into compliance with the various rules. Production reports is one of them. I didn't think to look whether the monthly production reports is one of the NOAVs. I don't think it is. I think but typically when we do an NOAV, we look at compliance for all the rules. And so I wouldn't be surprised to find that our enforcement unit has included that as an action item in one of those NOAVs. I think there's 4 or 5, maybe 6 NOAVs against Operating 31 that we are pursuing, that are progressing their way ultimately to you. And so I think that's probably the best summarization of that operator's status that I could give you without risking maybe speaking in an element that it is not before you yet.
And Commissioner, if I may add, sorry, one moment. Generally how these begin is through the commission complaint process. When we get these into our system, one of the first things we do is check production reports. And when they are not present, that goes on the radar of the people that check that. So that's something we can check again after this hearing, and I can get back to Mr. Cuthbertson and Director Murphy about that, and that can also lead to enforcement looking into a potential NOAV for failure to provide production reports as well. That's a path we have taken in the past with other operators.
Follow up, Commissioner McGowan.
No, thank you, Mr. Chair. And I feel like I'm being nitpicky about it, but it feels, I apologize. I'm feeling empathetic to the folks who are owed their share of the minerals, and then what seems to be two non-responsive operators. And I know Chair Robbins, you said last week, sometimes I don't respond because it's kind of an admission of like, you're right. But then when we don't hear anything, even them to say, you're right, my bad, I'm going to make the payment, it just kind of sticks in my craw. So I'm sorry that I'm picking on this. But I also think that, you know, then you look into all the other things that maybe the operator is or isn't doing. And you know, we're setting up these rules so that we have responsive and responsible operators in our system. And I want to make sure that I am constantly just letting folks know that I'm going to be paying attention to those things.
Commissioner Messner.
Thank you, Mr. Chair. And thank you, Commissioner McGowan, for nitpicking on this, because I think it is important and I appreciate your attention to it. I think we heard today from a number of operators about the social license to operate, right? And I think some of these issues that we're seeing, you know, in these, in these consent agenda items, you know, directly relate to operators maybe not listening to other operators about the importance of that social license to operate. And so I think these are good things to pay attention to. I think that's one of our responsibilities. And so I appreciate your attention to that.
Do we have any additional questions concerning consent agenda? Seeing none, do we have a motion to approve consent agenda?
So moved.
Second.
We have a motion and a second. Seeing no further questions, all those in favor signify by saying aye.
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 Any opposed? The consent agenda carries. AG Davenport.
Thank you, Mr. Chair. And I realize you said this at the outset, but I just want to clarify that the motion did not include the matter that has been pulled by staff on the agenda, which is, sorry, it's taking me a second to get back to the agenda.
2007-00176 Bowen versus CWC Petro, and I believe that we had already pulled that from consent, and so it was not approved. But we could poll Commissioner McGowan regarding her motion and Commissioner Messner regarding his second, if that would clarify the record.
No, as long as it's, well, sure. If the commissioners want to confirm that essentially that was just a group A
That
and
was
B
exactly
on the
my
consent
motion.
agenda. Okay. All right.
Great. Okay. We are to that portion of the agenda which precedes adjournment, and that is commissioner comments. Do commissioners have any comments? Commissioner Gonzalez.
Thank you, Mr. Chair. You know, today was a really, really great day in terms of presentations from Mr. Duranlo to the panels we heard from the industry, to Mr. Helling for the SEP program. Really enjoyed every bit of that, learned a lot today. I just want to thank everyone, not just for being here to present and being willing, but the preparation that went into these presentations was outstanding. So I just really appreciated that. And I learned a lot today, and good presentations, good questions all around. And that's my only comment.
Agreed. Commissioner Messner.
Thank you, Mr. Chair. And thank you, Commissioner Gonzalez, for helping put all that together. For me, that was a really important presentation, and I did learn a lot. And so thank you to all the folks that presented, but thank you for putting that together, Commissioner Gonzalez. I did have a couple of questions that, and these may be better to talk about on Friday. But I was trying to remember this morning kind of where we were at as far as the flow line mapping goes. And I wonder if we could get an update on that at some point in the future. I know that there was a deadline that was required for mapping. I think that was in the fall. I know that we were pretty close as far as that deadline, getting compliance, but not quite there. And I wanted to just know generally where we were at with the flow line mapping. And then maybe on Friday as well. I think we've initially kind of talked about the development of the technical work groups and maybe scheduled some folks that were going to be responsible for putting stuff together, but I can't remember exactly where we're at with that. So maybe that's a topic that we could talk about on Friday as well.
Excellent. I think that the commissioner comment section is a great time to tee up stuff for Friday. It gives Scott 2 days to be ready. Other comments from commissioners? I like to comment a little bit about just some of the outreach that I've been doing. We talked about that amongst ourselves, and just so that everyone can know, including my fellow commissioners. But you know, Commissioner Messner and I sent out invitations to Colorado local governments that we'd be happy to meet with them. And I've been doing some of that. And just to report out, I met with Garfield County commissioners at their weekly meeting this week for about an hour. I then met with La Plata County, both the county commissioners, the staff, and the planning commission for a couple of hours. Wanted to send out a big thanks to Craig Berger and Jim Hughes and Joel Miner from COGCC and the AG's office. They also attended and presented some great technical information to La Plata County commissioners and planning commission, and that outreach was good. I met with the Adams County oil and gas department and planning department for about an hour and spoke with them. And then along with Executive Director Gibbs and Director Julie Murphy, I spent most of last Friday in a consultation with the Ute Mountain Utes on air quality and oil and gas. And I think that that was well received as well. So just letting folks know what commissioners are doing in terms of the outreach. And so that's my report of happenings since last Wednesday when we last met. All right, well, I think we're gonna meet in our work session on Friday morning. I think that's 9 a.m. and anybody can listen in. We do not take public comment and there's no real agenda other than the couple of things Commissioner Messner has pointed out. So we will see everybody then. And with that, I would look for a motion to adjourn.
So moved.
Second.
Great. All those in favor signify by saying aye.
Aye.
Aye. Motion carries. Have a great day, everybody. Stay safe. Great meeting today. And thanks everybody for attending with us.